my lord.
You for respondent.
Respondent, my lord. Let it be first week of May, my lord.
Okay, respondent number.
Sole respondent.
Okay, sole respondent. Mr. Who is for the petitioner? Mr. M. Das, learned counsel for the petition is present. Stop. Mr. S. Bora, learned counsel for the respondent, has submitted that.
Respondents, my lord.
Respondents
Lord.
has submitted, on instruction, there are certain developments in the matter, and so he has therefore sought listing of the case after 3 weeks in order to complete his instructions in the meantime. So as the request of Mr. Bora is accepted by Mr. Das, let the case be listed on
11 May.
11.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 6, Lordship.
6.
Yesterday, they have filed an affidavit in reply. We need to seek some time for instruction.
Who is for the petitioner? You have informed your
Yes,
petitioner,
ma'am.
Mr.
DK Katari.
DK
DK Katari, appearing on behalf of Mdutto.
for the petitioner. Mr. M. Gogoi, learned counsel for the all the respondents.
1 to 7, Lordship.
Learned counsel for the respondent number 1 to 7 has submitted that he has received a copy of the affidavit in reply yesterday,
Yesterday.
and he needs some time to go through the same to complete his instructions first of all. He has just sought for listing of the case after 3 weeks as sought for and agreed to by the learned counsel for the party, list the case on so and so.
22/5.
Any interim order?
May fix it on
No interim.
7 or 12 of May.
No.
20.
Any interim order?
No.
Silo.
May I please, Your Lordship? With the consent of the respondent, I beg to mention item number 7, Lordship. The
Seven.
respondent have filed an affidavit in opposition. I want to file a reply to
Okay, Mr. A. Borua, learned counsel for the petitioner, has sought for and is granted how much time?
3 weeks time.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondent.
Respond.
Respondent
Excise
department. Excise department.
Yes.
Also, Mr. R. Goel, standing counsel excise department is who is present, has agreed to the has submitted that he has no objection to prayer. Please the case on strength.
22/5.
Obliged.
Obliged, Lord.
May I please, Your Lordship, I beg to mention item 9 of today's list. I'm appearing for the health department. Here we need to file an affidavit, Lordship. I'm seeking an accommodation, Lordship.
Okay.
I'm for the petition, my lord.
Mr. M. Sharma, learned counsel for the petitioners is present. Mr. H. Cholia, learned standing counsel,
Health department, Lordship.
Health and Family Department, has sought for and is granted. How much time?
Lordship, 2 weeks, Lordship.
2 weeks time to file the counter affidavit on behalf of the respondent. Say respondents first. The praise is okay. Leaves the case on so and so.
25.
I'm grateful.
20 May.
May I please, Lordship? Item number 4 and 5, Lordship. In this case, Lordship, PWD has filed affidavit, Lordship. We need to file the legend.
Okay, Mr. A.M.S. Mojumdar, learned counsel for the petition has submitted that he needs how much time? 3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondent PWD authorities. First, the praise the Lord leaves the cases on so and so.
25.
Obliged.
Supplementary list for motion, item number 17.
Yes, yesterday from the instruction placed,
My lord.
one annexer,
Annexure B perhaps.
annexer 19.3, annexer page 27.
My lord. My lord.
Seems to have been withdrawn.
Yes. And my lord, the bill which
And,
was
page 28, consequently, this disconnection notice also goes.
my lord. This is not a case of theft of electricity. This bill has been incorrectly issued, Your Lordship. I have
So this is the order.
now, Your Lordship, yesterday,
You have handed over.
I'm just handing over a copy. Sorry. This order was
That's
issued.
second for 2026.
Yes. No, a fresh order had been issued yesterday pursuant to the instructions, but since your lordship had directed that status quo be maintained, order has not been issued, it has been passed. So otherwise, this bill that was issued, your lordship, that has been erroneously issued.
Just a minute. The procedure, I might do it. Hmm? 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 Ah,
And disconnection also perhaps cannot be done unless it is a theft of, it is not a case of theft of electricity.
in his own premise.
It is their own premise, they have used it for some other
Maybe that
purpose.
is,
Yes.
your allegation may be different.
Yes, yes.
Theft.
No, this is not a theft of case of theft.
And there are 3 notices gives the number, meter number.
Now they have realized perhaps.
No, they have not realized. What do they say?
No, they are saying that unauthorized use of electricity,
How can it be
Uh,
unauthorized?
therefore, that assessment bill has been cancelled and fresh assessment bill has been prepared as per section 126. So this is provisional.
Milord,
Under
there is
126, the
Milord,
procedure is there.
no, first of all, Milord, they have given the classification. We have not classified. It has been going on for years. We are paying, they are accepting. Now, if they want that there is a mistake in the classification, there is a procedure prescribed. 126. And they have to give follow that procedure, give a provisional assessment, and then hearing, and then it will
Right.
follow.
That is what they are contemplating now. 126.
And classification of consumers, Milord. Where a consumer has been classified under a particular category and is billed accordingly, and it is subsequently found that the classification is not correct, the consumer will be informed through a notice of the proposed reclassification, duly giving him an opportunity to file any objection within a period of 15 days. The licensee shall finalize the classification after due consideration of the consumer's submissions. That's 232. Hmm? এখনো উপর দিছো নেকি সেইটো 232 There is a distinct procedure.
And that is there in the proposed one, provisional assessment bill.
There-
Type is change in category. Now,
If there
now
is
change in category, and this is under 126, and provisional assessment bill.
if they want to reclassify, because the classification is done by them, we have been given a classification, it is going on that basis. If they are now saying that there is a mistake in the classification, there is a procedure prescribed. You have to give a notice that we want to reclassify and it will be this classification. And we have to be given an opportunity and a hearing, and thereafter an order will pass and provisional assessment will come. This is the procedure. You are not following any of the procedures. You start with a notice saying that unmetered theft. And then, Milord, they say in the 3 notices, this is the meter number.
Now that has been withdrawn now.
I don't know, this is all, I mean, they should cancel this proceedings, you know.
This has been cancelled.
All proceedings.
Therefore, the above assessment bill number, that is, what is the bill number?
Your lordship will, what have they said here?
That bill number is annexed, Mr. Pathak, here in
The new bill is
26.
the earlier bill is at page number 22 of
22.
the writ petition, which cancelled bill. This has now been cancelled.
Where is the number?
The bill number, your lordship will find at the
Ah.
top of the page.
Yes, yes.
Page 20, kindly see, my lord.
This, just a minute.
Yes.
22. Page 22. Page 20 is an inspection report. Oh, that is their, page 20 is their preparation.
Yes, yes, that,
Page 22, that has been cancelled.
and
That has
Page-
been cancelled. That is what they now say. Then
my lord, kindly have a look at page 20 for a moment.
two.
Type of connection, domestic B.
Page 20.
Just one second. Just
They have prepared.
meter particulars.
They have prepared. What
Yes.
they have reported is a different thing.
Correct. You know, that's what
On
I'm
the
saying.
basis of that, they have
Right.
issued.
Type of connection, they are saying domestic B.
Right.
Mere meter particular, they are giving the meter number. And their notice at page 22 says non-existing consumer theft. And CD,
That bill number.
See-
Bill number. This has been cancelled now.
no,
Right.
what I am trying to show, you know, kindly turn to page 22. The
Yes.
way they are proceeding, unthinkable, you know, this is dated 7/10/25. And they are saying non-existing consumer theft of electricity. And kindly see hearing date 8/10/25. And this is a letter which is coming on 7/10, signed by on 7/10/25, already determining the amount. Huh? Now, my lord, if they want to go back, they have to go back right from the beginning. They should give a, my lord, follow the
Then,
proceeding.
secondly, this has page, what they are saying, page 22 has been cancelled.
Page
Right.
20, they have to cancel
Cancel.
entire proceeding
Right,
and the,
right.
and the
Just a
impure
minute.
notices.
Next is page 27.
Correct?
That has been cancelled.
20, 22, 26,
No, no,
and
22
27.
is their report.
Yes,
That is a different matter altogether.
yes.
Page 22. 20 is their inspection report.
Correct, Miller.
Page 22,
Two.
they have cancelled it.
Very good, Miller.
Then page
26,
26, there is no mention, but 27.
26, they are demanding the amount.
27.
And 27, they are saying that.
That has been cancelled. 27,
and
page
28,
27.
they have to cancel because this connection notice is 28.
That is in reference to
All
page
will
20.
go.
No, page 27. See the reference.
Correct.
19/3/2026. This has been cancelled. Then come to page 28.
Yes.
See the disconnection of this reference. Reference is of the page 27 order.
Correct.
That has been consequential. That is also good.
You know what I am saying? Let us not keep the jam. Cancel the initiation and as well all the subsequent impute orders. That's all.
They have decided to proceed afresh on the basis of a provisional assessment bill and under 126
No,
in the category change in category. If they are procedurally wrong, it is open for you.
no, what I am suggesting, my lord, your lordship has seen the position. the law says that if you are reclassifying, you have to give a notice, hear them, give a provisional assessment
Right.
order. Follow that.
Let them follow. If they go wrong,
But
it
this
is
is
always
not-
open for you.
No, correct.
I will not prejudge that.
No, your
If
lordship-
these are all cancelled
correct. I have
and
no
they want to
problem with that.
rectify themselves,
And if they want to
let them serve fresh notice. If you find
follow the procedure and give-
infirmity in that, you
Then
can
I-
challenge, or if there is no infirmity, you participate.
correct.
Now they want to say that there's deemed change in category.
No, that is where the problem.
Right, whether this, they have,
If you know, kindly see your lordship has got the
I have,
232.
this one, yes. If
If
they
they-
don't follow,
Correct, my lord. If they are classifying me with one category and they think that it is not correct, what they will have to do is prescribed. You have to give
So-
a notice, you have to give a provisional assessment and a hearing.
if they go wrong, they definitely.
That is all. I
So,
say.
Mr. Pathak,
But this can't be
whatever,
like
whatever has originated from page 22,
My lord,
and all consequential actions have been withdrawn,
they have been.
cancelled.
My lord. We will not proceed on 22.
22 or 20.
22 onwards.
22 onwards, my lord. And this
Hmm?
argument regarding classification, what this provision, otherwise the supply code has been repealed. As per the new one also, almost perimeter, what it deals with is, suppose today a consumer has been listed as domestic. We make a mistake in classifying that consumer. Then he has to be given a notice for reclassification. What has happened in this case is, he has a domestic connection, he is running a commercial PG, that amounts to unauthorized.
We are not into
Very
the,
well, very well, very
you
well.
proceed.
I'll not go into.
You
If it is
proceed
going to
accordingly.
happen,
We'll not go into that.
Give him the opportunity
Absolutely.
to represent and rebut
Very well.
as per the provisions.
Of section 120.
But so far as the challenge in this petition, all these have gone now.
Yes, yes. It is not a case of theft of electricity.
But 22 onwards,
Everything goes.
Yes, yes.
So if they go wrong in following the
I
procedure,
see, I quite see.
I cannot, at this stage, I cannot
No,
prejudge.
anticipate.
Okay.
But I thought, my lord, as a
Right.
public institution, you have to follow and deal with a aging lady. She is saying that wait for my sons to come, I don't know. And in spite of that, they follow and write all kinds of allegations, my lord.
The problem is that there is a statutory mandate, your lordship.
Heart,
Time periods are
Mr.
fixed.
Very
P.K.
good.
Goswami, Learned Senior Counsel,
It doesn't
explained by
violate the
Mr.
statute to give notice.
The BP Bora, Learned Counsel for the petition, and Mr. K.P. Pathak, Learned Standing Counsel, APDCL, for the response number 1, 2, and 3, first of in this writ petition, preferred under Article 226 of the Constitution of India, comma, the petitioner has assailed and electricity bill number with the 7/10/2025 bill and electricity bill number 300122 dated 7/10/2025. 25 or 24.
Wait,
Page 22 is
page 22, bill date is
17.
710.
7/10/2025.
25, 25.
25. On the subject, quote unquote, page 22, malpractice type, non-existing consumer theft of electricity. And then a notice bearing number, page 24, dated 21/2/2026. One, two, three, four করে দিব 3. A notice an order on hearing of SSM bill bearing number page 27 dated 19/3/2026 and a disconnection notice bearing number page 28 dated 24/3/2026 issued in reference to the order dated 19/3/2026. Post of Para, Mr. Pathak, Learned Standing Counsel, APDCL, has submitted on instructions that the bill number all the above no, the provisional bill dated 17/2025, bill number 30000122 dated 7/10/2025 and notice dated 21/2/2026 and the order dated 19/3/2026 and the consequential disconnection notice dated 24/3/2026 have been cancelled. And since the respondent APDCL authorities have materials to proceed under Section 126 Electricity Act 2003, comma, the authorities are contemplating to proceed in accordance with proceed in a matter by following due procedure. By following due procedure.
Due procedure.
Due.
Under the law.
Under the law. Right.
This is also not as per the law. Therefore, I want your lordship to.
This order has not been issued because your lordship had passed a status quo order yesterday.
That is why I have said.
Yes.
You have decided to cancel.
Yes.
Post of in view of the decision to cancel the above, the challenge to the repetition, challenge made in the repetition are no longer required to be adjudicated.
And the impugn orders are set aside.
They have cancelled. I have said they have cancelled. They have taken the decision to cancel.
All the three, my lord.
All. Inspection report, that is their report. That may be the basis.
But that we should get the follow-up opportunity.
Sure. That is what.
Yes.
Post of. The repetition is accordingly closed. Post of. Is therefore closed. The documents placed by Mr. Pathak are kept with the case record by marking them as document A collectively.
Only there is one little thing. The inspection report is by some officers. The law requires that it is only authorized persons can inspect and give that. If that is not done by an authorized officer, my lord, this has no validity. Therefore, do not give that, my lord, approval.
No, I am not giving it.
That your lordship.
I have maintained silence on it.
Your lordship should make that even that inspection report We are not admitting that it is correct.
I am maintaining silence on it.
Okay.
Whether that was properly inspected or not, I am not saying.
That question also remains open.
Supplementary list, item 18.
Because we have challenged the inspection report also. Therefore, your lordship will have to
Okay.
mention that. This is also-
In this petition, the petitioner who is a senior citizen, comma.
I know that inspection report also needs to be done in accordance with law. That's all.
Lordship, that inspection, if it is done today, now that they are aware that an inspection is going to happen, they will.
No, I'm not making any
Yes,
comment
yes,
on
your
it,
lordship.
neither its validity or invalidity.
Very well, your lordship.
No, then your lordship may keep that open, that whether it was authorized officer who did it or not, that's a question.
Lordship may grant them the liberty to challenge the inspection report in a subsequent proceeding.
We
if
have
they
said
so
it,
desire.
that's why I'm taking the trouble of.
No, I have said, apart from the inspection report, I have said all other orders from 22 onwards have been cancelled.
True, but the inspection report is the basis, whether it is done by the authorized officer also.
Okay, the senior counsel has submitted that the inspection report prepared by the respondent, inspection report
Prepared by the officers.
prepared by the officer of the respondent APDCL.
Whether or
Is also not as per proper procedure. Full stop. If it is so, comma, it is open for the petitioner to sorry, it is open, no? The liberty stands reserved to the petitioner to assail the same.
deeply obvious.
Deeply.
Item 18.
Please, Lordship, for the response, we are led by Mr. D. Saikar. He's on legs in court 10, my lord. Lordship, may kindly pass off the matter for the time being, my lord.
After the motion,
My lord, may I do one thing, my lord? In the meantime, in court number 24, my next item is the
Okay.
motion. So I may do in this man.
okay, we'll accommodate
Both the sides, my lord.
both the same.
Deeply, my lord.
Item number 19.
Main is an option. But I'm preferably on a small, very small premise, my lord. I run a restaurant, I think, in the Gau Panchayat area. Now, I had prayed for renewal of my trade license, not knowing the fact that by a notification.
Your
I placed-
secretary makes a comment,
My lordship.
right? The Gram Panchayat secretary makes a comment on your application.
So that is one part.
And secondly, you say that there is a notification.
So trade license part, I'm not insisting.
Huh.
But what reflected on mine is says, if there is a public complaint, the secretary otherwise did not communicate it to me. But if they take an action against me without.
If it is honest, nothing there is, he has no jurisdiction to
No,
make
no,
any
no.
comment.
The jurisdiction.
According to page 25.
No,
Go
jurisdiction.
for RTI then.
No,
No, we are not the forum for RTI.
that, you know, I could not place my submissions perhaps correctly. So far as trade license, I'm not on that.
Then on what?
Because the complaint was not served on me. I had no notice of the complaint. Tomorrow, if the secretary takes a call on the complaint, then my entire business will go, me.
The secretary does not have jurisdiction according to you.
No, only on the trade license. But
Yes.
Complaint is.
On what?
On the complaint.
After that, what he can do? Tell me.
Gau Panchayat area, if they issue one line order,
Huh?
he may not continue.
He will come with goons or what?
They may pass a restriction order, Miller.
What kind of? Then you come. We are not preempting everything.
Then that liberty may be granted, Miller.
What liberty? You are always armed with the constitution.
I am, Miller. But
And
the situation
CRTC.
is such- He's,
CRPC.
and then at least,
CPC.
then at least this may be observed, you know.
No,
that-
no, no, no.
Yes,
We,
we should not take that as
unnecessary observation we are not going to make.
But rightly or wrongly, on the trade
If
license part also, we are
Your,
exercising
if
jurisdiction.
this comment that you are saying, Mr.
My lord.
Where is that comment?
Lordship files, you know. Annexure C at page 16. Type version C, page 16.
And this comment is to be read with page 25 notification.
Correct.
Right? Then what else? There is nothing.
Basically, I was not on this part. I was on that part. He's on and off to take an action against me on the
Okay,
basis of.
you want a blanket order.
No, 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 no. Nothing on my part.
Absolutely, then if you
Lordship,
make
my
submission, I am
addition to prayer,
disputing
my
with
lord.
cost then. If you want to make such submission.
I do not need on a trade
No,
license
no,
part.
no. What can be?
Prayer may be seen, my lord, page number 9.
Yes, yes.
Totally premature case, my lord. On presumption, this.
Give an opportunity of hearing to the petitioner.
He is acting on that.
He has no jurisdiction as per your own case.
Yes, yes. On the trade
Page
license.
25.
Until
I'm
then,
not
no
on the trade license
order
part.
has been.
Otherwise, it.
No notice has been issued to you. How can he give the hearing? There is nothing. And so far as this notice is concerned, it is addressed to some Narayan Das. Page 15. And you are Pritam Das.
Yes.
That is also honest. If you are the owner.
I'm known by that name.
Right.
I'm known by that name. I'm known by that name. It's okay.
That I don't know.
I understand. This part is a different procedure.
No. We don't want to, but just because this comment page 16. Request cannot be accepted. He cannot renew the license, so whatever he makes, whatever comment he makes,
He cannot.
let him make.
Obliged, Lordship.
Page 25 is
Yes,
clear.
yes. He did not know that I played on record.
He cannot renew the
Correct,
license.
sir. Cannot.
He can write anything there.
That's
Where not, not-
that's the only thing which was bothering us for long.
if he takes any
Then
action,
we'll come again.
constitution is available to you.
Certainly.
Right? Constitutional protection is always available. If he takes any criminal action, then
In fact, my
here
lord, page number 15 was issued by the co-district commissioner, not by the secretary. Not by the secretary.
The party-
Prayer is against the secretary,
right.
but this notice is by the.
Brought to light.
He got it.
Brought to light.
I'm being fair enough. This is a separate thing against me. I'm participating there. I'm not nothing on that.
Shall I dismiss it or?
Let the matter come up on the 20th.
No,
No, my lord.
no point. Then I'm dismissing it.
Lordship may close the issue because without the instruction I cannot withdraw. It's really difficult.
Then I'm dismissing it.
Lordship may close it in the fact that in page of 25 they have no jurisdiction. That's all. That would do.
Misconceived. I'll say misconceived. Misconceived
Perhaps
petition.
he
No,
don't want the word dismiss.
Huh?
He don't want the word dismiss. That is.
Misconceived, so closed. Hard to miss that. As one for the petition.
But one thing remains: the secretary still does not know he has no jurisdiction.
Let him act on it.
Lordship.
Mr. S. Dr. as Panchayat, Standing Council Panchayat and Rural Development Department for the response number 1, 2,
1, 2,
4,
four and
5. And Mr. M. Setia Leonard,
is for
Junior Government Advocate for the response number 3. First up. The petition, English petition prepared under Article 226 of the Constitution, the petitioner has sought for a direction to the respondent authorities, more particularly the respondent number 5, that is the Secretary Jhargaon Gaon Panchayat District Morigaon, to give an opportunity of hearing to the petitioner in respect of an alleged complaint lodged against the petitioner. Full stop. Para. The basis for seeking. It is ever in the petition that the basis for seeking such a direction is a remark, is an endorsement made by the respondent number 5 on an application submitted by the petitioner before him on 7/2/2026. Full stop. In the endorsements. Now, full stop. By the application, the petitioner had sought for renewal of the trade license, which was earlier issued to him by the Jargaon Gaon Panchayat to run a restaurant within the areas of the said Gaon Panchayat. Full stop. Run a restaurant by the name and style of Kakoli Restaurant, Kakali Restaurant at Jargaon Bazaar, which is within the areas of the said Gaon Panchayat. First of on the body of the said application, the respondent number 5 had made an endorsement on 11/2/2026 to the effect that the request for renewal could not be accepted due to problems and complaints received from public. First of para. The petitioner has also annexed a notification number so and so dated 25/4/2022, page 5, issued by the state government in the Panchayat and Rural Development Department, whereby the state government has rescinded the requirement of issuance of trade license by the Gaon Panchayat in setting up business activities, shops, etc. Full stop. In view of the notification dated 25/4/2022, issued by the state government, issued by the Panchayat and Rural Development Department, Government of Assam, it is evidently clear that the respondent 5 has no power, authority and jurisdiction for either for issuance of license, trade license, issuance of a trade license, for setting up business activities, shops, etc. Full stop. Therefore, it is inherent in the notification, the secretary of the Gaon Panchayat also does not have the power, authority and jurisdiction also to renew the trade license. Full stop. Therefore, any endorsement made on an application, on the application of the petitioner, application for renewal submitted by the petitioner before him, has no effect. Full stop. Consequently, the writ petition is found to be misconceived, and therefore the same is closed.
That observation.
Item 20.
In this matter, Lordship, an NIT was issued, Lordship, on
NIT?
7/2/2022 for
Which one?
selection. For selection,
Page
page 18, Lordship. I'm reading from page 18.
18.
18, Lordship.
18? 18 is your, 18?
NIT is in phase number,
Which page?
starts from 36, Lordship.
Okay. Selection, appointment of handling and transport contractor for transportation of food grains. Yes.
The contract period, Lordship, was for 1 year, Lordship. That is 2022 and 2023 financial year, Lordship. And Lordship, that is stipulated in page number 39, Lordship, of the NIT. Accordingly, Lordship, after the due tender process, Lordship, work was allotted to 7 bidders, Lordship. So, Lordship, thereafter, Lordship, after the elapse of the 1 year, Lordship, there was no fresh tender process was initiated, Lordship. Thereafter, they have been issuing monthly extension orders, Lordship, issuing, allowing these respondents, private respondents, to work. 5 of them has been engaged, Lordship, as of now, Lordship. Because of this, what is happening, Lordship? These people are working after till 3 years, Lordship. Since 3 years, Lordship.
What right of the petitioners have been
Yes, Lordship.
has been infringed?
GPSs are an integral part throughout this distribution process, Lordship. So what is happening that the food grains that has been collected from FCI godowns to GPSs and thereafter it is distributed to the fair price shops, Lordship. There is a serious, Lordship, mismatch of weights, Lordship, and that is happening in every month, Lordship.
So are you making complaints or not?
Yes, Lordship, we have preferred on
Where?
representations as well, Lordship. That is there in page number 57, Lordship.
57.
Yes, Lord. Before the
What do we have to do, Minister? We have nothing to do with Minister.
we have stated in the representation that we have already preferred representation
nothing
before
to
the
do with Minister.
authorities as well, Lordship.
We have nothing to do with Minister.
Yes, Lordship, but in the representation we have stated that
Before whom
We
you have all our Minister. Let him interfere. If you have approached the Minister, let him interfere. We have nothing to do.
no action has been taken till date, Lordship.
Minister, not the pursue the Minister
Even,
after his election again.
even minister also subject matter, my lord may kindly see the subject. Even minister also subject, lordship. Application for granting permission to leave the rights allotted, lordship. And now he is coming against that.
We are not considering page 57
Lordship.
to 64.
Lordship,
Page 57 to 64. Leave aside all this in
more
your
about, Lordship,
submission.
there is another aspect, Lordship.
Ah.
GPSs are also can participate in the tender process, Lordship. They have not been able to.
So you are agreed by the extension of
Yes,
the
Lord.
transport contract.
Yes.
Okay. But who are the beneficiaries?
Beneficiaries are the Lordship.
Are they-
Applicant general, Lordship.
Are they? These are the beneficiaries, respondents.
No, these are the private respondents who have
6
been.
to 10.
Yes, Lordship.
They are the beneficiaries. They are the beneficiary transport contractor.
Yes, Lordship.
They are running on extension.
Yes, yes.
Yes, Mr. Gogoi.
Madam, you should notice that this is this.
Heard Mr.
W. Ram.
W. Raman, learned counsel for the petitioners. Mr. K. Gogoi, learned additional senior government advocate for the respondent number
1 to 5
2,
lordship.
3, 4, 5.
5 lordship.
Full stop. The petitioners, 26 in number, are Gaon Panchayat Homobai Homitis, GPSS, having their registered offices in Nagaon district,
No.
Assam. Full stop. The petitioner GPSS Moles have projected that in the public distribution system, they are important stakeholders as their role is in their role. They have a distribution role in the two-tier system.
Yes.
Namely, tier 1 within bracket FCI Godam to GPSS stroke WCCS Godam bracket close, and tier 2 within bracket from GPSS stroke WCCS Godam to fair price shop dealers stroke agents bracket close, full stop. Para. The respondent number
Six to 10 Lordship.
5 on respondent number on 7/2/2022, comma, the respondent number 5 published a notice inviting tender NIT for selection stroke appointment of handling and transport contractor for transportation of food grains under the NFSA-2013 for Nagaon district. Full stop. By the NIT, comma, the tender process was initiated for selection of contractors, transport, handling and transport contractors for carrying, comma, loading, comma, unloading of allotted food grains, i.e. page 36, rice under NFSA-2013 in two-tier system. That's a tier box to tier 1, tier 2. Full stop. By the tender notice, it was made specific that the contract period would remain in force up to 31/3/2023. Full stop. Even after, but after expiry of the contract period, comma, the respondent number 5 had extended the contracts from time to time, with the last extension on. Where is the last extension?
Last section of 19.3,
Which page?
page number 65.
With the last extension on
19/3/2026.
2026 up to
They're issuing it on monthly basis, Lordship.
also. The petitioner, so GPSS, have experienced anomalies in the distribution system, as they are an important, they are stakeholders in the distribution system and are competent to operate as handling and transport contractors, comma, the petitioners EPSS have represented before the authorities to initiate fresh tender process for selection of handling and transport contractors for the Nagaon district, as their representations, such representations have not been paid heed to, and the system of transportation have been allowed to continue on ad hoc basis by way of extension. The petitioners, TPSs, are before this court by the instant petition. Issue notice returnable on so and so, as Mr. Kaushik Gogoi 125, no formal notice, extra copies within 2 working days from today. Steps upon respondent number 6 to 11. Up and line likhiko. And it is a respondent number 6 to 10, who after being allowed or who after being selected as the transport contractor, handling and transport contractor for the year 2022-2023 have continued to operate as such on ad hoc basis by way of extension, and such system, according to petitioner, GPSS, is illegal and arbitrary. Steps 6 to 11 by speed post within 2 working days.
2505. Item number 21.
Peace, Your Lordship. Lordship, here the petitioner is aggrieved by the cancellation of the trade license of the petitioner, Lordship. The petitioner was running a scrap materials in her dam, Lordship, under the Tinsukia Municipal Board. And accordingly, a show cause was issued to the petitioner, stating that some antisocial activities are involved.
Right. You said that your appeal is pending.
Lordship, page 30, appeal is pending. Lordship may dispose of the matter directly. Page 30, Lordship.
6 months, Lordship, my appeal has been pending. Neither the appeal.
Appeal is pending before whom?
District Commissioner, Lordship.
Commissioner. So, Mr.
Lordship,
Gogoi,
Lordship may dispose of
how much
directly.
will be the time required?
Lordship, election is going on, so Lordship, 45 days.
45
After
days.
15,
Now election
Lordship.
up to 6th of May.
Lordship.
After that. So today is what?
Today is 8th of
8. So 8 to 8. 30 days. 1 month. 1 month means. Okay. You have waited. So by 31st of May.
Lordship.
31st of May.
Lordship.
Heard Miss M. Nirola, learned counsel for the petition, and Mr. K. Gogoi, learned additional senior government advocate for the respondent number 1 to 3.
120, Lordship. 120.
Not 5.
5, no, 5.
5?
5
Huh? Mr. S. Botakur, learned counsel for the respondent number 4 and 5. Full stop. Para. The petitioner has stated that she had been carrying the business stroke trade of scrap materials in her dump in the name and style of Messrs. Kalpana Dump. Post of the dump is situated at Hijuguri VIP Road, Ward number 15, Post Office and Police Station, Tinsukia, Assam, which is within the territorial jurisdiction of the respondent Tinsukia Municipal Board. Oslo. The petitioner stated that she was running the business after obtaining a trade license bearing number SCP-196 issued by the respondent municipal board, 196, and renumbered as it has a synopsis by the respondent municipal board. The last renewal was up to 30/3/2024. On 18/3/2023, a show cause notice was served upon the petitioner, asking the petitioner to show cause as to why the trade license of the petitioner should not be revoked, cancelled, and why, and as to why the damp premises should not be sealed with immediate effect. Full stop. In response to the show cause notice, the petitioner submitted a reply on
2012,
on
2012, 23.
2023. Full stop. But without any prior opportunity without providing any opportunity of personal hearing, the respondent number 5 has cancelled the trade license of the petitioner by an order dated 27/12/2023, purportedly exercising power under Section 231 of the Assam Municipal Act 1956 as amended. Post op. By the impugn order dated 27/12/2023, the petitioner was directed to stop any activity in the dump premises till further order. Post op. Aggrieved by the impugn order of cancellation dated 27/12/2023, the petitioner had preferred an appeal under Section
233.
233 of the Assam Municipal Act before the respondent number 3 on 29/10/2025. Full stop. (29/10) or 22/7/2024.
So that is earlier the petitioner has filed,
Okay,
but the
okay.
same was disputed, Lordship.
Okay. 29/10/2025.
That is pending.
Full stop. As the said appeal has not been given consideration by the appellate authority, that is the respondent number 3 till date, and as a result, the very livelihood of the petitioner has been affected. During the interregnum, the petitioner is before this court by the instant writ petition, seeking inter alia direction to the respondent number 3 to consider the appeal on merits and thereafter to dispose the same in an expeditious manner. Post of Mr. Gogoi, Learned Additional Senior Government Advocate appearing for the respondent. Number 1 to 5 more particularly, the respondent number 3 has submitted that if the appeal preferred by the petitioner under Section 233 of the Assam Municipal Act 1956 is still pending before the appellate authority within respondent number 3, the court, a direction may be issued to the appellate authority to take the appeal for consideration and thereafter to dispose of the same on its own merits. First of all, he has submitted that a period up to 31st, a period of 6 months would be sufficient for the appellant authority, would be reasonable and sufficient for the appellate authority to consider and dispose of the appeal, considering the fact that presently command a mode of what is called, what is that called? Enforce.
Model code of conduct as well
Model
as.
code of conduct is in vogue. His Neurola Learned Counsel, appearing for the petitioner, has submitted that if a time period, if within a stipulated time period, the appeal is disposed of, then the petitioner is agreeable to the same post of para. In considering the fact that the appeal, the appellate authority, this court is of the considered view that since the damp was being run by the on the basis of the trade license issued equal to the cancellation of the trade license has a bearing on the livelihood of the petitioner. First of, since as against the order of cancellation, the petitioner has preferred an appeal on 29/10/2025. And a period of more than how many months?
6 months, Lordship.
More than 6 months have elapsed in the meantime, the appellate of the respondent number 3, who is discharging statutory functions as the appellate authority, is expected to dispose of, was expected to consider and dispose of the appeal in the right earnest. First of, as taking into account that presently the what is this called?
Model code of conduct.
Model code of conduct is in force. This court is, or this petition is disposed of with a direction to the respondent number 3 to consider the appeal filed by the petitioner on so and so that in an expeditious manner, and thereafter to dispose of the same on its own merits, and thereafter to dispose of the same by region order as expeditiously as possible, and but not later than 31/5/2026. Most of it is accordingly ordered. This order disposes of the writ.
Item 22.
Admitted amount of the bill of the petitioner, my lord. Tally, page 19, my lord.
What is
Yeah,
the
bill
prayer here?
Was supposed to, my lord,
What is the prayer here?
they are for release of the admitted amount of bill.
What kind of contract?
There are the, my lord.
Where is the
development,
contract?
My lord,
Where is the contract?
where when software development
Tender?
and data entry.
Work order?
Work order, my lord, I could not file, my lord, page 19, kindly see. I submitted all the documents before the authority as required, my lord, for release of my
48 crore.
48.
Who is he? Farijuddin?
The director of
A work order was placed in whose favor?
My lord, e-tender, my lord.
E-tender.
E-tender.
Farijuddin individual capacity or director? Huh?
He's a director. my lord.
Private limited.
Director of Zolos
Then-
Private Limited, Lordship. Zolos Private Limited.
How can he, managing director,
Lordship.
how can he file in his own name?
No.
So, Farijuddin.
Lordship.
If the
Joloso.
Joloso Private Limited
Lordship.
Yes, my lord.
is the contractor to execute works of 48 crores,
My lord.
how can the person in his individual capacity can prefer a petition?
Kindly,
It can be by it can be Joloso Private Limited
my lord.
represented by the managing
Lordship.
director or by any authorized signatory pursuant to a board of resolution of the board of directors.
My lord.
This petition I find to be
Lordship.
Allow me
48 crores. If he
to,
says that I am the contractor,
Lordship.
no doubt, then you can maintain. But if
He's
it
the
is
director, my lord.
in the amount, he himself says director.
Lordship.
Yes, ma'am.
Even Lordship, the annexure also reflected it, Lordship.
Annexure reflected.
No, I don't find this is maintainable.
আপনি একটু উদ্যোগ করে রিফাইল করো।
By the name of the company, represented by Farijuddin as the managing director.
Then allow me to,
And also 48 crores, and you don't have the
Tender.
work order.
Work order, tender, nothing was annexed also.
what is there, my lord, only ship is 19.
No, that is not work
Everything
order.
well.
That is not work order.
They
That is not work
acknowledge,
order.
and
I don't know. I have some
also acknowledge
serious
the
reservations.
contracts of performance.
I have some serious reservations. Oh, shall I hold it to be not maintainable?
Allow me to rectify my lord. Title
Refile it.
and then
Refile it. Heard Mr. A.J. Atia, learned counsel for the petition. And Mr. K. Gogoi, learned additional senior government advocate for all the responsible topic. Mr. Gogoi has pointed out that the petition has been filed by the petition in his individual capacity, whereas it appears that the work order, which has not been annexed to the petition, was issued in favor of one Messrs. Zoloso Private Limited.
Lordship.
First up, submitting, so he has submitted that the petition in the present form is not maintained. So Mr. Atia, learned counsel for the petitioner, after making a submission at some length, has submitted that the petitioner or the petition may be allowed to be withdrawn in order to file afresh with proper details and in the correct form.
Lordship. Lordship.
In view of the above submission made by Mr. Atia, learned counsel for the petitioner, and taking note of the submission made by the learned additional senior government advocate, Mr. Gogoi, learned additional senior government advocate, the petition is allowed to be withdrawn. So the petition is accordingly dismissed on withdrawal with the liberty to the petitioner to file afresh in the correct form
Lordship.
and with proper details.
Lordship.
Full line. I don't know. Yes, both the councils are not available.
Time being method.
Okay, after some time.
Daily list for admission. Item number 1.
Lordship, may kindly peruse order dated 13/3/2026. Instruction was sought for you.
Lordship, in this case, my lord, may I kindly grant some time to ask, Lordship. We have written to the authority, Lordship.
Okay.
Due to the election, they have, Lordship.
One more election will be added now.
Lordship, Lordship.
So better you clear all
Lordship,
the,
otherwise also, Lordship, here I have gone for it, Lordship. It says that sub-divisional officer, he himself, Lordship, admitted that particular amount, Lordship.
okay,
In that-
definite instruction on the next date.
Lordship, Lordship.
Mr. Heard Mr. UK Dekal, landed counsel for the petitioner. Ms. Pete Hapa, landed counsel, appearing on behalf of Mr. S. Dr. Landed Standing Counsel, Panchayat and Rural Development Department for the respondent number 1 and 2, and Mr. K. Gogoi, landed additional senior government advocate Assam for the respondent number 3 and 4. Close to there. Mr. Gogoi has submitted that after the order dated 13/3/2026 of the court, he has already communicated
On 19th, we have.
the matter to the respondent number
3 and 4.
3 and 4
3 and 4. Lordship.
on
On
19/3/2026.
26, Lordship.
And the response is awaited. So he has submitted that in view of the model code of conduct, some more time be granted to him in order to obtain definite instructions in the matter. Post of the request of time made by Mr. Gogoi appears reasonable. Post of in view of the model code of conduct presently in force. Post of and the prayer is for time is therefore accepted. Leaves the case on soils.
Lordship, Lordship.
1305.
Lordship. Oblige, Lordship.
Item 2.
Number that has filed.
Believe is your yes.
Lordship, the health department has already filed an affidavit, and on behalf of PWD, we have also received the instructions. We'd also like to file our affidavit.
What kind of instruction? Tell me.
Lordship, we've received quite a lengthy pairwise comments.
Lengthy.
Yes, Lordship.
What is the stand of the respondent in the health department?
They are stating as stated by the my lord in the impine order, my lord.
Impugn order? Which is the impugn order?
That is page 47, my lord.
Yes, what is it?
Paragraph.
Defect liability period is over. Completion certificate was earlier issued.
Issued, my lord.
Therefore, is a reasonable ground, basically, sum and substance.
Lordship. Paragraph number 5 of our affidavit in opposition, Lordship, from what I have read, it would be relevant, Lordship.
Who is this hospital management society?
Lordship.
does it have any role in the process? Yes, Mr. Where is your tender notice?
Page 53, madam.
Let me have a look at the annexes.
Page 53, madam. The executive engineer.
Just a minute. GMCH.
Yes, madam.
When it was completed? 16/9/2021.
Yes, madam. And Lordship may kindly see page 53, one letter.
Page?
53, madam. Where it is stated, the defect liability period is 1 year, madam. And it has already occurred.
Page
53, madam, and except 12.
Yes, Mr. Bhuya, what justification you have received? Yes. Mr. Bhuya, what justification you have received?
It's Lordship. Regarding the PWD, Lordship.
Because page 53 is your own executive engineer.
Lordship. Lordship, that is why we have a
Any
very voluminous.
justifiable ground?
Lordship.
Apparently, no.
Lordship. Defect liability period has already been over. Lordship, in that case, let me file our affidavit. We will also obtain our instructions regarding this. Something will come on record as well.
Nothing will come on record. Simple, arbitrary.
Okay.
Somebody has decided, some extra departmental authority has recommended something, you have acted on it.
Okay.
Earlier, your stand was different all throughout, all your officials. Now somebody else has come. It might be some elected person was heading that body. Okay.
That is
Cut
also
from him.
after
Heard, Mr.
3 years, madam.
I have understood. Ziuddin, learned counsel for the petitioner. Mr. Miss D. Bora, Land Standing Council, Health and Family Welfare Department for the response number 1 and 2.
But 10.
She also 3
10 and 11.
and 10 and 11. And Mr. M. Bhuya, Land Council on behalf of Mr.
4,
P.
5, 6,
Gogoi,
7, 8.
Land Standing Council, Public Works Department for response number 4, 5, 6,
7,
8, 9.
Lordship.
9. First of all, the response number 10 has already filed its affidavit in opposition. First of all. So no other affidavit is required from other respondents. And Ms. Bora has submitted that. Huh?
This is the instances.
So please tell me, otherwise I am closing from our health and family welfare. Principal Director Medical Education has already submitted an affidavit. Whether that his stand is the stand of the respondent number one, or you want to get more clarification.
Yes, sir. So I have to obtain instruction from one.
Okay. Miss Bora, in the understanding of the Health and Family Welfare Department for the respondent number one. And Mr. Supriya, counsel for the respondent number 1 to, sorry, 4 to
9.
9 have submitted that the respective counter affidavits will be filed within the next date of listing without fail. If a time period of 4 weeks is given, post of the prayers made by Ms. Bora and Mr. Bhuya are accepted, lays the case on after 4 weeks DDO.
2505.
Much obliged.
Okay.
No, better by the just come, healing it. Okay, I'll come back.
Other promotion. Item number 18.
খেলিও আহিব মোক মাৰিবৰ কাৰণে আহিছা Well, in fact, two legal issues I am raising in this petition. Whether after the tender process is started, whether the eligibility criteria or other conditions can be altered or not. More particularly after the closure of date of the bid. Secondly, whether after the closure of the bid, the date can be extended or not. That is the two issues which I am raising in the writ petition. If your lordship just assume like that. For the convenience of lordship, like short, the page wise I am prepared. Other side of the one. The tender document. You'll also find as page 54. It's honest.
Yes.
उनको दिया
Charter hire of one number of drilling rig package,
My lord.
3,000 HP.
My lord. And in the below the line, lord, the bid closing date and technical bid opening date.
Yes.
Now the eligibility, you'll also find it page 63. Technically see page 64. Close 4.0. If any time prior to the deadline for submission of the bids, the company may for any reason, whether at its own initiative or in response to the clarification required by the respective bidder, modify the bid document through issuance of an addendum, corrigendum or amendment. So before the at any time prior to the deadline of the submission of the bids. Now, you'll also see page 85, the bid evaluation criteria.
Evaluation criteria. Yes, please.
Page 85, my lord.
Yes.
All India Limited is planning for dealing of a well so-and-so, and losing the execution of the job. The bidder must have the following experience at 3.1.1. During the last 7 years, reckoned from the original bid closing date. Bidder must have the experience of so-and-so. So you also see from the bid closing date.
Original bid closing date.
It
Must
was-
have.
Earlier, you also see execution of the contract, it was only for 1 week.
Yes.
Now thereafter, my lord, on 4/2/2026, an amendment was made which you'll also find at page 575. Prior to that, my lord, number of amendments were made, only extending the dates. It starts from page 575. You'll also kindly take the table of 575.
Yes.
This is the revised bid evaluation criteria. Bid closing date 19th February. Technical bid opening date 19th February. You'll also may see kindly 577. Part 3. The existing clause and the amended clause.
Yes.
Now we also can see at page 622.
Restriction is 601.
For that, I may take a loss to 602 after the amendment. Lord.
The amendment, there were two restrictions.
Page 602, my lord.
Yes.
Clause 3311. These were the additional restrictions which imposed, which were not there earlier in the original bid. Now page 603. 909 is one. Now the 4.1 below. It was made to 84 crores. Earlier it was 109 crores. Earlier it was 1, now they made it 2. So for 1, 84 crores and for 2, 168 crores. Earlier for 1, it was 109 crores. I'm just showing Miller that the various amendments which have been made. Thereafter, Miller, see page 622.
Now from number 1 rig or it has been changed to increase to 2 rigs or what?
2 rigs,
In the meantime, it has been changed for,
2 rigs.
the requirement is to,
Earlier Miller for 1 rig. Now thereafter they made it 2 rigs. Subsequently again changed to 1 rig. Again. Now 622 you'll also mechanically see. It is
Last extension.
where is amendment number 14?
14,
630.
whereas 622 Miller, page 622.
Amendment number 14. And where is amendment number 13?
30 को दस है?
621.
Page 6, huh?
621.
621 Miller. All earlier were Miller for extending the date.
621. Revised. 19 9 okay, 9 then 18 okay, 622 is 18 extended up to 27 February.
27-2.
Hmm.
That was the last. We filed the bid Miller before the closing, that is 27-2. Now we'll also see page 623. That is on 23 2026 Miller. It says that amendment in tender documents so notified about the following. Amendment in few tender clauses including BEC are tabulated by so-and-so. Performer bid price bidding format stands revised and has been uploaded in so-and-so notes and attachment. Bid closing date is extended up to 10th April 2026 and technical and operating date on 10th April 2026. So after the closure of the earlier date, Miller, after 3 weeks, the amendments have been made and the date has been extended. Now, the amendment you'll also may see at page 624. Earlier, which was 2 weeks, again it has been made 1. Or page 627, you'll also make a see. At the right hand side, Miller. Originally, Miller, for 1 week, it was 108 crores. Now it has been kept at rupees 84 crores. This only I am showing, my lord, that certain amendments which have been made after the bid process started and after closure of the bid. Now, the issue which is arising for consideration for your lordship is that, my lord, whether after the bid process is started, whether the amendments can be made, and that too after closure of the bid document. Secondly, whether after closure of the bid document, the bid date can be extended or not. On that, my lord, I place before lordship the judgment of this honorable court also, as well as the judgment of the apex court, including your judgment of your lordship, my lord. Your lordship may kindly note, my lord, clause 4, which I placed before lordship, my lord, that before closing date, the on the request, either on the basis of company or on the basis of the bidder, they may make the suggestions and the amendments may be made in the bid consultation meeting, my lord, but not thereafter. What's the child copy called? Kotor? This one. Manish Chaudhary, too. Who question was away?
Where is the part 2 of the bid document?
My lord, part B, the this. My lord, is at page 85. Yes, I was. Typically, Manipur apologize. No. And the one. कोई से लोन आई लोन माई लोन आई थे आप
Yes.
So these are the short facts because I'm not going to the legal issues which are there. First of all, although there are various judgments, including the judgment of the apex court, I will take the judgment of your lordship first. Thereafter go with the other judgment. At serial number 9, my lord, at page 162. At 11 part at page 175, para 20.
Yes.
As you also got it, Lord? Page 175, para 20. Any relaxation or revision modification in the standard of eligibility at the time of considering the application would amount to denial of the opportunity to those who considering themselves eligible did not apply for the response of the advertisement. For example, there could be persons who are also in possession of same kinds of lands we two petitioners bear, but after going through the criteria set forth in the unified guidelines with regard to the nature of land required for the offered for LPG distribution, one or two advertised locations as so and so did not apply in response to the advertisement, and in the event the responding authorities may award the LPG distribution for the two advertised locations by relaxing the revising the criteria set forth in the unified so, then the shade would amount to denying those persons from the privilege of participation, and the same would be in violation of Article 14 of the Constitution of India. It is also settled that once the game has begun, it is not open for the authority to change the rules of the game in the midstream. Any relaxation or revision or modification in the original terms of condition would amount to rearrangement of the goalpost during the ongoing process, affecting the rights of the some of the denying the privilege to others, which is not permissible. Now I will take a lordship below to page number 1 and para 12. You'll also find at page 6.
Monarch.
My lord,
Yes.
in the middle, my lord,
Yes.
the only question,
Page 6 or para 6?
page 6, para 12, my lord,
Page 6, para. Yes.
in the middle, my lord, the
Middle.
only question therefore remaining. Have you also got it, my lord?
Hmm. Yes.
The only question therefore remaining is whether a contract should have been awarded in favor of so and so. The High Court has taken the view that if the terms of tender having been deleted after players entered into the arena, it is likely changing the rules of the game after it had begun. And therefore, if the government or the municipal corporation we are free to alter the conclusion first process of tender was the only issue. Therefore, we find that the course adopted by the High Court is in the circumstance is justified because by reason of the deletion of a particular condition, a wider set will be permissible with a large participation of more attractive bidders could be offered. Dr. Losim, can you see page 8?
Yes.
Page 8, my lord. The relevant part at page 12. The last 2 lines of the page, my lord. It has been repeatedly held by this court that the rules of the game, meaning thereby the criteria for selection cannot be altered by authority concerned in the middle or process after the process of the selection has commenced. Therefore, the decision of the High Court to the extent it pronounced upon the invalidity of the circulated so-and-so does not merit consideration in the same so-and-so is set aside. Hereafter, also can you see page 14 and the relevant part at page 19, my lord.
Yes.
Para 14. The High Court is committed an error in holding that the extent the amended rule was operative, as has been fairly considered by the learned counsel for respondents applicant. It was unamended clause that was applicable. Once a process of selection starts, the prescribed selection criteria cannot be changed. The logic behind the same is the fair play. A person who did not apply because of a criteria so-and-so, minimum personal mass can make a legitimate grievance in the case the same is lower that he could have supplied because he possess the said percentage, rules regarding the qualification of the appointment if permanent during the continuance of the process of selection do not take the same. That is because every statute or statute rules is prospective unless it is expressly or an implicit implication made to have a retrospective effect, unless there are words in the statute so and so.
So far, in this case, the ultimately by way of corrigendum, the last date with submission was extended.
Right.
Right. And last date as per amendment of amendment number
14.
14, it was 27 February 2026. And you submitted your bid
On 27.
before that. So you are awaiting opening of technical bid, right? Then after that, it has been extended on 20/03/2026, and bid submission was extended up to 10/4/2026. So you are already in the zone by submitting in the bid. You are not outside the zone.
No.
Right. So from that standpoint, what kind of, yes, it may be for a person to allege violation of Article 14 in the sense that evaluation criteria has been changed by, say, 620 page 624. It was earlier 2. Now here they say their requirement is 1 now from 2. That they may have.
Earlier 1.
They may have.
Well,
that we cannot say what are their requirements. Anything on eligibility criteria of the participant bidders, because requirement may change. Sometimes it may happen that I need a 10-story building. Later on, say, no, it will be not possible.
They may need 1. They may need 2.
May need 2. Whether for participation.
But I was submitting for lordship, Lord, subject to Lord. I could get your lordship also.
Because from an outside bidder who was seeing everything, initially 1, then suddenly changed to 2, then that person may not have the criteria, suppose. Whether it is eligibility part where it is materially changed.
If after closure the bid date cannot be extended.
Right, that is 1.
But if cannot be extended, then all other things fall through, my lord. And
right.
this honorable court has held that after the closure date, the bid extension cannot be made. I will just take your lordship to the judgment, lord. Unto judgment. What is? 194. No, it's 191. No, I will take it as an answer. Please. They are mixing up, my lord. I will take your lordship to page 198. And page 211.
211. Yes.
Para 24, my lord. Clause so-and-so authorizes the employer for extension of the deadline for submission by issuing conditional. So-and-so authorizes the employer to modify the bidding document before the deadline of the submission of the bids, which is so-and-so. The deadline for submission of bids covers only the online bids, both technical and financial only, but not the date and time of submission of the bid. Hard copy of the technical bid, as the requirement of hard copies for verification so-and-so. Clause 18 of the so-and-so is tractable, but as there was a violation of clause 10(1) while issuing the corrigendum for extension of the end date of submission of the bid, which was published beyond the time period stipulated, according the amendment so introduced was invalid and void of an issue. The extension of the bid submission end date would have to be valid had the same was notified prior to the expiry of the deadline of the submission of the bid, that is so-and-so. In the respondent sheet, though participated in the tender process and was better, but after entering on the field of competition was inherently defective. The date of submission of the technical bid on or before so-and-so as stipulated in the appendix is held to be the typical error for the state above. Now a valid tender must offer his or her proper time and a place as held by so-and-so. The respondent was submitted a bid so-and-so on an invalid amendment caused by the employer, respondent so-and-so. As such, the extension of the bid date is void of an issue and the offer of so-and-so does not fall within the valid offer. Actually, fresh bid only option possibly.
The option.
Number one. Yeah. What is actually? Look at this one.
No, and that.
To my submission for lawsuit that Miller. Here the question of jurisdiction is there. Whether they have the authority, jurisdiction, to extend the date after closure date and make an amendment. If they have no power to extend the date after the closure date, then whatever amendment they have brought, that will be illegal. And the Supreme Court has said, there are 14 extensions from the very date, extension date, thereafter amendment. Now, under such circumstances, certainly a doubt, I'm not saying that it is correct, but a doubt certainly creates in the mind of the bidder that these amendments which have been made necessitated were for the purpose of favoring a particular bidder. May not be correct, but a doubt certainly created in the mind of the bidder. Now, as the Supreme Court has said, at page 1, paragraph 12, that under such circumstances,
Page?
page, my lord,
Page number
6. I may beat paragraph 12, my lord. 1 second, my lord.
Yes.
If we bear these principles in mind, the High Court is justified in setting aside the award in question, contract in favor of so-and-so, because it had not fulfilled the conditions relating to so-and-so of the tender notice, but the same was deleted subsequent to the last date acceptance of the tender. If that is so, the argument advanced on behalf of so-and-so in regard to the allegation of malafidis of the Commission so-and-so in showing special favor to so-and-so or to the other contents raised in the High Court and rated are insignificant because the High Court has set aside the award made in so-and-so. The only question therefore remaining is whether any contract could have been awarded in favor of so-and-so. The High Court has taken up the view that if the terms of tender having been deleted after the players enter the arena, it is like changing the rules of the game and it has become, and therefore if the government or municipal corporation was free to alter the conditions, fresh process of tender was only alternative person permissible. Now, my lord, submission before a lawsuit is that, my lord. If so much confusion is there, for 14 amendments have to be made, 13 times the date has to be extended. And even after the closure date, where the technical bid was to be opened on the same day itself, and it is not opened, kept for 3 weeks, and thereafter a corrigendum comes again, my lord, then in my humble submission, my lord, it can be said that the tender process is not fair, which is violative of Article 14 of the Constitution of India. Now, my lord, your lordship also raised a query that what restrictions were there. But your lordship has seen by Amendment 12, 2 restrictions were imposed. Now, again, that restrictions have been deleted. Now, I am posing question to myself, my lord. You put a restrictions, you withdraw it. The rate is 1008 crores, you make it 84 crores. You again said the financial bid in this form you change and you submit. My lord, under such circumstances, whether it can be said in the touchstone of Article 14 of the Constitution of India that the tender process which is being they are going ahead is a fair one, which will not create any apprehension in the minds of the bidders. Because after all, the purpose is a fair tender process, and there should not be any apprehension in the minds of the bidder that all such exercise, you put a restrictions after the issuance of the bid, subsequently after 3 weeks of the closing date, again you withdraw the restriction. There must be, you know, cannot be done like that. Otherwise, you know, there will no end. The state can always change the criteria, change the dates, the closing date, the technical bid opening date will have no meaning. Because lordship has come across the cases where after the opening of the technical bid and after looking into all those, the state feels that no, we have to go for the fresh bid. They have the power with the regions that why they want to go for the fresh bid. But it cannot be that the state has the power to make the amendments in the eligibility criteria, financial conditions, withdraw the restrictions, that too after the closure date, last date of the submission of the bid. You don't open the technical bid on the date which is specified. And 14 amendments are made by extending the dates. And 3 major amendments are
Whether
made.
by this corrigendum.
Well, corrigendum, but
No,
corrigendum,
no, just a minute, my query.
my lord,
Whether by this corrigendum, they have allowed new players to come in?
that is not mentioned, my lord.
No.
It is not mentioned. But it is presumed that they will allow. Now, you'll also see the both sides, my lord. If they allow it, then the rights of the earlier one is violated. Because you, after the tender process is closed, over, you are allowing others to participate. And if you are not allowing them to participate, then these conditions or changes affect the right of the bidders who have already participated and submitted their bids.
Yes.
So my humble submission is that, you know, that after the technical bid is open, they will find out who is responsible, not responsive, all those things. And they have also the power to cancel the entire bid process by giving the regions a fresh bid. But under these circumstances where 14 amendments, 14 extensions and is made, but in my humble submission, that doesn't meet the test of Article 14 of the Constitution of India. That in short, my submission is follows. And in view of the judgments of the various judgments which I placed before Lordship, it cannot be changed. Otherwise, there is no end to the procedure. Everybody can continue it, everybody can change it at any time they like. And when the clause specifically foresays that before the closing date. Now the closing date, once it is closed, it cannot be extended.
And all those amendments are published where? In the portal.
Portal.
Portal. And when it was increased from, requirement was increased from 1 to 2?
But that was in the second 1 over 2 could leisure. By 12th amendment, my lord. By amendment number 12.
12.
My lord. At page 577. We may need 12, 2, 3, 4. There is no difficulty because more participants will be there. Lordship, can I see that original bid, it was 108 crores for one bid, one rig. Now it is reduced to 84 crores for one rig.
Now page 77
My lord. Page
is the experience criteria
Page 77.
or requirement?
My lord, just. Interesting.
Is 77.
My lord.
Page 577.
I'm sorry.
Clause 2.0, where the amendment has been brought in.
My lord.
Original 2.0 is where? Original 2.0?
Original 1, my lord.
No. Original clause 2.0.
2.0 original clause. Argument 12 बोलेगी. Page 85, my lord.
Page 85. This 577, it says clause number 2.0.
2.0. 2.0 plus no.
Page number
Page
512.
85.
512 of the tender document. Just a minute.
याते के लिखी है इसमें.
Page number 99. Page number 99.
Well, let me see page 54. my lord. I'm sorry, page 54.
That is scope of work.
Scope of work, my lord, page
Scope of
50
work.
54 at 2.0.
Then page 100. While the services of 1, 2, 2. Page 578.
My lord.
Earlier, clause was
My
the service provider shall provide the services of one number of
bid,
rig.
my lord,
Then amended clause was
two numbers.
two numbers.
My lord.
And was it brought down again?
Again, one, my lord. Page 625. Six 24, my lord.
For point now. Putting one number rig. Or putting. Whether this option was available for the bidder when it was increased to two, that to bid for one or bid for two.
One was also available.
Oh, one can bid for one rig also. So it has been brought down for two rigs, different financial parameter. For one different, for one is 84. For two it is so and so.
But earlier
Now-
for one, it was 108 crores.
Huh.
For one, it was 108 crores earlier.
For two,
One. First, my lord, first, it was one rig, and for that 108 crores was there.
where did you say that? You just said, you pointed out to that. You pointed out to
My lord, I have
somewhere.
page 96, my lord.
Page 96.
105 crores. 4.0.
This has been changed from time to time. Time to time. Last when it was changed.
105 crores was there. Then for two, consolidated was there. Then for one, now it has been made kept as 84 crores.
Which page you have shown earlier?
96, you'll also find
No, that is the original.
original one.
That was original.
Thereafter,
That has been changed.
no, no, I'll just show you. Okay. Wait. 602. 603, my lord.
It is there. Bidder can submit offer for one
My lord,
or for two also,
my lord.
and for both different criteria.
Now your lordship is 4.1 at page 603.
602, 3.3.11. A bidder can propose one,
My lord.
and 3.3.11b, bidder can offer for two also,
also.
right? Now thereafter they
My lord,
found out that they need only one.
no, only,
rig.
your lord, you see page 603 also.
I have seen.
That for one, they have reduced to 84 crores.
Oh, yes.
And for two, 19.74 crores.
This is when?
This is by the 12th amendment.
Prior to
Closure.
closure. So this remained.
This remain.
Now, by the last amendment, after bid closure, they have brought the requirement to one. So it resulted into deletion of this second
clause, by law.
that 3.3.11b as well as the requirement of 168 crore. They may require. The other question remains. I am trying to find out.
Certainly, my lord, you are absolutely correct. My lord.
So this had gone because
Because two is not required now.
because two is not required. Because if it was not open for the bidders to offer one or two, but to offer for two only, then it is completely, the change is tremendous. But here, this requirement one brought down to one, And the second criteria, higher criteria, price of 168 crore financial and two bid, that has been brought down. That has been brought down.
Milo.
Right. So
So you correct, Milo.
the other question remains.
Certainly, Milo, this is the factual thing is, Milo, this is the correct put.
No, any eligibility criteria has been changed.
Milo, the eligibility criteria, I will say that the restrictions which were imposed, that has been withdrawn.
Now, for bidders to qualify,
There were two restrictions.
what restrictions?
Yes, 3.3.
Same one. It says no, that is okay.
What was the
Number 626.
626.
These are the. There is no violence. There is no violence. Restrictions are put into the person.
The last one you also see bidder to provide daily dealing operation report 24 hours in minimum, 1 day signed by so-and-so, which already establishes that the risks other than the offered risks to oil are in operation as on the bid closing day.
This will submit
is
it against the
required to
above
so-and-so.
clause. Bidders proposing to offer for 1 week shall be required to demonstrate availability of either one or two rigs condition already mobilized and those supported by third party clarification.
That the rigs were in operating condition, which must be certified by a third party.
Hmm.
And the third one,
Hmm.
they must provide the daily dealing operations prior to that.
Original Bitcoin must be illegal. Before bid closure date, what is the annual financial turnover criteria?
Financial criteria.
Before the bid closing date,
Well, just
what is the
Page 96.
financial criteria change करो ना. Financial conditions, नहीं, capabilities.
this is the page 96 was the original one.
Yes, Lord.
603. 603 change position again.
105 crore.
Yes.
That was, you know, 105 crores was, as I pointed out earlier,
Huh.
that was brought down to 84 crores.
84 crores.
Well,
84 crores. In the meantime, or sorry, I used to forget.
originally, it was for 105 crores.
105. Then
Thereafter, 12th amendment, it was brought down to 84 crores.
84 crores.
And
So it remained, 84 crore remained.
84 crores means. 4-1. And 2 have been deleted.
2 have been deleted.
I know.
The reason being they require 1.
That it appears to be the reason.
Where in amendment number 12, this financial criteria has been changed.
603 million.
803. It is part of which document?
Well, this is the amendment, revised bid.
Huh? It's that the document starts from
Document starts from, my lord. 575.
revised. So financial criteria has been brought down to 84 for one rig
One rig.
and rupees 168 for two rigs.
My lord.
And that remained
84
also
remain-
for one rig for
84 crores.
84 crore. Okay. Yes.
This is my understanding.
Now we're at 2 o'clock. I can start also, no issues.
Okay, let's start.
So now the issue which my learned friend is trying to project, he is not agreed by any of the amendments except amendment number 15. If Lordship is pleased to come to the prayer page. Page 46. So all this from one rig to two rigs to one, and also that turnover amount, these are not the issues which he is actually aggrieved of. So page 46, prayer number 1, as to why writ of certiorari should not be issued, cancelling and or setting aside amendment number 15. And or last line, Lordship, the whole tender process should be set aside. A very interesting case. He is not agreed by amendment number from 1 to 15, but he is deliberately suppressing a very important fact from this honorable court. I'll come to all the changes and I would like to bring it through an affidavit. On 26/2/2026, he submitted an application before the IEM. But before that, I'll place it. Lordship will kindly see 2-3 points. Page 73, regarding bid extension. Lot of issue has been changed, why the closing date has been changed, or whether we don't have any authority. Page 73 of the writ petition.
73.
Page 73, 18.0. Normally, no request for extension of bid closing date and time will be entertained. However, oil at its discretion may extend the bid closing date and or time due to any reasons. And these reasons are not because of oil's initiative. It is because of the initiatives of various bidders. They are requesting some changes. They approach the IEM. What is IEM? Lordship will kindly see. If there is any dispute or any clarification they want, then they can go to the IEM, before the IEM. There is an authority under the central government. Page 81. Here two clauses are very important. Integrity Pact 31.1 and 31.3. May I read it, Lordship? Integrity Pact. Oil shall be entering into an integrity pact with the bidders as per format enclosed in pro forma M of the bid document. The integrity pact has been duly signed digitally by Oil's competent signatory and uploaded in the Oil's e-portal. The integrity pact shall be returned by the bidder along with the technical bid signed by the same signatory who signed the bid, that is, who is duly authorized to sign the bid. Uploading the integrity pact in the Oil's e-portal and digital signature with digital signature will be construed that all pages of the integrity pact shall be signed by the bidder's authorized signatory who has signed the bid. If any bidder refuses to sign integrity pact or declines to submit the integrity pact, their bid shall be rejected straightway. In case of a joint venture, all the partners of the joint venture should sign the integrity pact. In the event 31.3, in the event of any dispute between the management and the contractor relating to those contracts where integrity pact is applicable, In case both the parties are agreeable, they may try to settle their disputes through mediation before the panel of independent external monitors in a time-bound manner. If required, the organization may adopt any mediation rules for this purpose. In case the dispute remains unresolved even after mediation by the panel of IEM, the organization may take further action as per the terms and conditions of the contract. The fees, expenses on dispute resolution shall equally shared by both the parties. The bidders may contact the independent external monitors for any matters relating to the IFB at the following addresses. So these are the persons, these are independent persons. So if now they can come out that after the contract is signed, this is applicable. No. During the process also, they can approach, and which they have done. They have done. And this last application, they did not get a favorable order from IEM. That is why in a camouflage way, they have filed this writ petition to cancel the whole thing. What is the core issue they want to raise before the IEM? The last closing date, the original closing date, Lordship has just seen that. The original closing date we have not touched. It is not tinkered. Whoever is eligible on that last closing date, the original closing date, their eligibility criteria should be fulfilled on that particular date. Even after from time to time extension is given, they can only submit their bids, and also if they want to do some changes in their bid, then they are allowed to do that. Even today, they have already submitted, they can change it till tomorrow. On 10th, it will be open. They were not qualified, or we have not touched any of the eligibility criteria. Lordship has put that question several times. No correct answer has come. Our stand is there is no change in eligibility criteria. He was not eligible on the last closing date, original closing date. That date is 7/10/2025. And this application, which they have submitted before the IEM, says that they are eligible in the month of December only, and they want that relaxation. This is the actual game of this whole writ petition. All these things are not relevant, because we have done regarding all the 15 amendments till date. These are minor things, and these are at the initiative or at the behest of the prospective bidders or bidders. It is not because we are running out of time. Because of the present war situation also prior to that, we are in extreme urgency in public interest that we have to start this rigging at the earliest possible time. We did not have any intention to extend it, but just to give them fair level playing field, this has been done. So now they are also not agreed by from 1st to 14th amendment, and 15th amendment, that is just a cue they have taken to challenge it. But their main issue is, which they have not disclosed before this honorable court, and therefore my first submission will be that due to, for the reason that they have deliberately suppressed a vital material fact from this honorable court, this writ petition is liable to be dismissed on the ground of they are not coming with clean hands before this honorable court. That application, let me place it. The application dated 24th February. Seros to Rambhal Power IPS, member of Independent External Monitor, which is the part of the RFP. Lordship, may I read it? Seros Oilfield Services Limited respectfully submits this representation in connection with the tender floated by Oil India for hiring 3,000 HP drilling rigs. Oil published the subject tender on 3/9/2025 with the original bid closing date on 7/10/2025. Subsequently, the bid submission date has been extended from time to time through multiple amendments and presently stands extended to 27/2/2026. In this regard, we respectfully bring to your kind attention that Seros Oilfield Services India Limited is presently the only Indian service provider operating a 3,000 HP drilling rig under contract with oil. During execution of the ongoing contract with oil, we have successfully achieved the required qualifying credentials prescribed under the tender, including drilling operations involving well depth of 4,500 meters with displacement of 2,000 meters on 10th December 2025, which is well prior to the current bid submission date, that is 27 to 2026. Despite fulfillment of the technical experience requirement before the last date of bid submission, the existing bid evaluation criteria provides that eligibility shall be assessed with reference to the original bid closing date, that is 7/10/2025. Consequently, an existing and proven contractor of oil possessing demonstrated operational capability under oil's own contract stands excluded from participation. They have participated. We have not assessed the technical bid till now, but they know their condition. What is there? And they have given all these things. Next, I am skipping 2 pages. The second last page. I am skipping the Excel sheet part also. The above sequence clearly demonstrates that substantive amendments relating to scope of work, contractual conditions, and bid requirements continued even after the pre-bid stage, while the eligibility reference dates alone remain frozen to the original timeline. That is the correct position oil has taken, Lordship, in my humble submission. Because if the last date is extended from time to time, in the meantime, lot of person will get eligible. And if I am not eligible, I'll try to play a game to delay it so that in the meantime, I acquire, which precisely they are doing. In fact, 1 or 2 amendments were done at their initiative also. I will give the complete chart. So they have requested for changing the original closing date, which was rejected because Lordship will kindly take my chart, small chart I am giving. The Lordship here, I am giving the complete chronological chart. Here, if Lordship is pleased to come to the second last page. আমাকে এখন কেটে দিয়েছিল 20 তারিখ না application. Yes, Lordship will come to date 14 to 2026. The petitioner again submitted a request to oil on 14, have Lordship got it, the last one, 14 to 2026 to amend the BEC clause that the technical experience of the bidder to be evaluated from actual bid closing date rather than original bid closing date. That is the request. Oil did not respond positively. Therefore, they went before the IEC. Then the IEC passed an order at 2/3/2026. IEM hearing was held on 2/3/2026, wherein after due deliberations and after hearing all the parties, oil and the respective complainant, IEM gave the conclusion as below. MS Seros, IEM did not agree to the request of Seros and did not find any merit in their contention. That is the application. So this is the core issue. So therefore, my humble submission, without delving any further submission at this stage, I would like to place this application before this honorable court through a short affidavit. And my prayer would be that this writ petition in the present form is not maintainable at all.
Just a minute. 2/3/2026.
Lordship.
B.
B is for other party.
No.
Please
read.
IEM rejected one request, but on the other request of BEC provision, IEM found merit and advised oil to review its clause.
Next.
20. Since one of the conclusion out of the above did not come in favor of oil, it was finally decided by the competent authority to go ahead with the tender as per IEM advice. It was also decided by the competent authority that the original tender conditions for hiring only one 3,000 HP rig instead of
There lies the answer.
Yes, we are restored to one.
That is what?
Yes, Lordship. In view of, that is that 15 amendment also.
Read further.
In view of above, the tender opening could not be done, and then amendment 15 amendment was issued on 23/2026 to revise the tender condition to decrease the risk hiring from 2 numbers to 1, delete the BEC clause as per IAM verdict, and the bid closing date was extended to 10/4/2026.
What is the authority of the IAM?
IAM is a central government.
Page. That authority you have shown?
The authority in the
document.
in the document it is there, Lordship. Page 81. So this is an independent agency,
Right.
Lordship. All the parties, both the parties can approach them in case of any dispute or any clarification. Regarding changing of the closing date, Lordship, it is permitted and it is within clause 18.0, page 73. That clause is also there. Normally, no request for extension of bid closing date and time will be entertained. However, oil at his discretion may extend the bid closing date and or time due to any reason. So no prejudice has been caused to anybody. We do not have any blue-eyed person to favor, or we do not have any persons whom we do not want to discard. It is not a case like that. We do not want to Lordship.
Number 16, my lord. The matter has been
settled, my lord.
settled
Both
my
the
lord,
parties.
before mediator, my lord. And mediator report is before lordship, my lord. On 18/3.
Will I have to incorporate the terms of settlement?
Yes.
In the order. Okay. As Doctor, Senior Counsel, listed by Ms. Boro
Yes, Mushar.
and Ms. Aforesaid. Responded.
Yes,
Okay, I'll close this on the basis of mediation report.
obliged.
Apart from this, my lord, another item. I'm for the respondent. Did you receive?
Item
For
number?
the petition, item 8.
Yes.
With the election commission, they have filed an affidavit. It is not on record.
Okay.
Today they have filed. Today, my lord, they have filed. So let it come on some other day. Another similar matter is fixed on 29th. So
Okay.
it may be fixed on that day.
Mr. D. Chakraborty petitioner. Mr. Dr. and Senior Counsel standing. Senior Counsel for the respondent Silsa Vinitzel board has submitted that. And Miss who is
Mr. Dubey, yes.
And Mr. Dubey, Learned R. Dubey, Learned Standing Counsel, Assam State Election Commission is present. It is submitted that the respondent Assam State Election ASEC has filed an affidavit in the matter, and the state affidavit is not tied with the case record. First of, they have sought for Learned Counsel for the parties have sought for listing of the case on 29/4/2026 with the state affidavit of the respondent ASEC on record. List the case accordingly on so and so. Registered to test out the affidavit of the respondent ASCC to tag it with the case record, list the case on so and so. As sought for Learned Counsel for the parties.
Much of this.
Yes.
Item number 10, my lord.
10.
The department has to file affidavit till today, my lord, they have not filed, let it be after review petition.
Yes.
Karbi Anglong, my lord.
Karbi Anglong.
Yes, ma'am. Irrigation plan.
Okay. On the prayer, Mr. T. Sheikh, Learned Counsel for the petitioner, list the case on so and so.
1305.
Only thing, one more. After this bleed closure date, two say applications were filed before the IEM. One was accepted, one was rejected. Petitioner's application was rejected. Now, whether the other one, what kind of merit, whether it has changed the situation or not, that would need a disclosure in your affidavit. Lordship.
Not after, prior to closing date. This was prior to the closing date,
No, your closing date, that is
last closing date, no,
last closing date, thereafter extension.
prior to that.
This IEM held its meeting on 2nd of March.
That they have, held, but we have filed application prior. to-
So Lordship, if we look at their prayer, they have prayed, the first prayer is regarding they have challenged the amendment number 15. And there is a word and or. They have three other prayers. Page 46. So page 46, the first prayer, that amendment 15 should be set aside. And last two words, and or. So alternative prayers are there. If I take the word or, that the whole tender process should be set aside. That is P9/2025. Then 3 is basically same, restraining the authorities from invoking amendment 15. And there are certain interim prayers. So either amendment number 15 should be set aside or whole tender should be set aside. This is their prayer. That's what whether two alternative prayers. So if amendment 15 is bad in law, by assuming that the grounds they have changed, that no closing date should be can be changed, and there can be no amendments. This is the thrust of their main argument. And on that basis, they have also cited some judgments. Those judgments are absolutely not applicable in this case because the terms and conditions of those tender notices were totally different. Here, if they are aggrieved by any of the clauses of the tender notice, Lordship, then they ought to have challenged it at the very beginning, at the very outset. Not at this fag end when there is only 1 day left for opening of the bids, the technical bids, which is day after tomorrow. The tender document itself says extension of bid submission date is permissible under clause 18.0 at page 73, and also amendment at page
Clause 18.
Clause 18, page 73. Normally, no request for extension of bid closing date and time will be entertained. However, OIL at its discretion may extend the bid closing date and or time due to any reason. So that reason Lordship can always examine if there is a challenge, but that is not put to challenge straight away.
This is also not in the foresight, it is an exception otherwise.
Is it an exception?
Otherwise,
So-
in the exception,
so-
so how far on the basis of IEM can extend? We'll examine that, but so far it should, since the application is for, I have seen the content of the application, their application also. So we have to taste this, so there is no precedent.
What is their actual?
To my knowledge, I have not read, I have not come across any such case.
Because these are actually now what is their actual grievance? Their actual grievance is that in the month of October 2025, they were not eligible. That is their actual ground. To bypass that, they are challenging the whole tender process now, so that if a fresh tender, because lot of times they were also praying that fresh tender notice should be issued. If fresh tender notice is issued, in that situation, Lordship, the original closing date of the bid will become a new one. So that is their actual grievance, which they are trying to do in a different way. Indirectly, they want to do. But while coming before this honorable court, when they say that amendment number 15 is bad in law because this is not permissible under the jurisprudence of tender activities, Lordship, that a condition one set cannot be changed. But here, page 64 again, Lordship will kindly come. Clause 4.0, amendment of bid document. At any time prior to the deadline of submission of bid, the company may, for any reasons, whether at its own initiative or in response to a clarification requested by a prospective bidder, modify the bid document through issuance of an addendum, corrigendum, amendment. The addendum will be uploaded in OIL's e-tender portal in the tab Technical RFX and under External Area Amendments folder. So everything is set in the whole system. The company may, at its discretion, extend the deadline for bid submission. Bidders are expected to take the addendum into account in preparation and submission of their bid. Bidders are to check from time to time e-tender portal, Technical RFX tab, and under the folder amendments for any amendment to the bid documents before submission of their bid. No separate intimation shall be sent to the bidders. So they were well within the scope and within their scope of things regarding submission of tenders. Everything is there in the portal itself. So it was properly notified when they have participated. And they have not challenged clause 4. They have not challenged clause 18. We are exercising the discretion. But what we have done, that due to certain evolving situations, like how the pre-bid meetings they have taken place and what are the points raised by various bidders, and after due application of mind, not through a mechanical way, certain changes are required. And this is a very elaborate and very extensive tender process.
That is why this QIPO, that entity made two requests.
Yes.
One request is BEC provision, and I am found merit in that provision, right? If that has changed the situation, we will examine. But for the timing, the process would go on. But
Process will-
but the system, if suppose it will be upon disclosure of QIPO's request, it made two requests. One was rejected, the other was exceeded. And that is in the BEC, bid evaluation criteria. Right. But we don't know what is the criteria.
Till now, we have not evaluated. It's a premature case.
No, that is why let us have the affidavit from the ONGC.
And let us go ahead with the tender process.
Yes, but if he is, suppose by that way, something has been treated discriminatorily, and by that, QIPO is allowed to go in, that I don't know as on
Yes.
So we'll examine that.
Lordship,
everything is subject to
the issue notice. Whatever decision we take, that may be subject to final outcome of the report.
And that QIPO's approach to the IEM needed disclosure in your affidavit.
That may be indicated also in the order.
Well,
And also, Lordship, during this time, if they want to change any bid value or anything, that is permissible also. Till day after tomorrow.
That Dr. Saraf knows he can.
He's smart enough, Lordship. I mean, his client.
Yes.
no, I am also, why you are saying I am not?
I will say he is super smart. I am trying to give him a better adjective.
Because you say smart enough, thereafter he's saying client,
No.
No, that-
I'm not on that. I am only on the bid document, that's all.
Lordship, can you see, no? My learned friend has relied on two clauses. Clause 4.
64.
And I'll also raise the issue of non-disclosure of substantial material facts, whether it is deliberate or whether it is fatal.
All issues will be open.
Lordship.
Page 64, Miller.
Yes.
Any time prior to the deadline of the submission of the bids. Lordship, can note it, Miller. So it can be only prior to the deadline of the submission of the bids. Now, you'll also, my learned friend also submitted the clause, company has the power. Hmm? 18%. And also 73. Page 73. Clause 18, Milord.
Yes.
Normally, no request for extension of the bid closing date and time will be entertained. However, all oil at the discretion may extend the bid closing date and so without reason. Lord, the bid closing date may be extended. But after closing, whether it can be extended or not, that is the issue. 12 times they've extended, we have not objected. Prior to closing of the date, they may extend. But whether after closing the date, whether it can be extended or not, that power is not there. If, my lord, it is presumed, my lord, that after the closing date also, that date may be extended and any other persons may be allowed to participate. The entire tender process will become a mockery. Can, my lord, my learned friend said that he can make an amendment or whatever you want, change it. Look, can after closing date, the bidder can be allowed to change his bid? It cannot be allowed. My lord, the question is that whether they have the jurisdiction or power to extend the date after the last date of the closure of the bid. First. Second, whether after the closure of the bid document, whether they can make any amendment. My lord, the question is that if there is jurisdiction is there, if assuming my lord also comes to a conclusion that yes, they have the jurisdiction. That jurisdiction, my lord, your lordship is aware, my lord, they can do anything. As your lordship, my lord, I don't know about the judgment. My lord, the question of my learned friend said what prejudice question will not come. If there is no jurisdiction, there is no jurisdiction at all. Now, my learned friend replaced the
What kind of authority does IEM have?
This is a lordship. I have the guideline. It is under CVC, the central government response.
He is not the bidding, the authority, he is not the authority. The bidding document has to be issued by a particular authority of the company. He is not the authority. It is an external agency. Any authority outside the person who has issued the bid, outside authority cannot dictate the authority who has issued the bid. Now,
Yes.
my learned friend has said that the process may go on. From my side, I may just place before lordship. My lord, according to them, anybody can file the bid, now change it and do it. I have not submitted a fresh bid because fresh bid will have to be submitted as per the corrigendum number 15. The fresh bid will have to be submitted, a fresh format has been given of the financial bid. Now, if your lordship may not observe in the interim, just subject to my lord, that the process may go on the basis of the 15th. The last date is 10th. The submission of bid is up to 10th. Those persons, earlier persons also have to submit a fresh bid in the new format.
Format has been changed.
Format has been changed, financial bid. Now, if I don't submit, then I'm out. If I submit, then it will amount to accepting the 15 notification which is challenged by me. Now, for last bid was issued on last date was in October, no? Last first bid. First bid date your lordship can see in September.
Yes.
Today we are in April. If for 7 months there was no urgency, can it be said, my lord, that without examining the issue, whether they have the jurisdiction or not, they can be allowed to proceed? And that too, the deadline is there 10th.
Yes.
The deadline is up to 10th.
Yes.
I submit, then I accept it. If I don't submit, I am out.
Obviously, that will be without prejudice to this repetition.
Now, below the submission, my subjective logic, what I want to say below, that this 15, I'm not saying about the entire process. Your lordship is examining the entire issue.
Yes, obviously.
Your lordship is examining the entire issue. The prayer which Mike said, although they should also not suffer.
Whether in the process, fairness required to be maintained is
Well,
not maintained or not, or Article 14 is violated. That is the.
My submission will follow lordship will be subject to my lord consideration. I just negotiation. The petitioner will submit his bid first in terms of the 15 notification. That will be without prejudice to the.
Absolutely.
The secondly, the process may go on up to 10th, but it will not be reopened. The tender process, if it is reopened, my lord, then there you lordship is aware the technical bid is open, the financial bid is open, everything. Third party rights will be created. Because the third party rights also will be created now. Now 10th, up to that, the whatever the bids will come, their rights will also be created. So it will be a very peculiar situation, my lord. So first submission, my lordship, will be there that this 15 should not be given effect to. Your lordship, the date will be there. They have extended, they will again extend it. If your lordship comes to a conclusion that they have the power to extend it, they can extend for 5 days more. There will be no difficulty at all. And if lordship comes to a conclusion they have no power, then the whatsoever may be there, it will go. If lordship comes to a conclusion that they have the power to extend the date even after closure, there will be no difficulty because the 5 days more they will extend and the people will come and finish it.
Power to extend is an exception, right? As per the tender document, for the purpose of simple understanding as on date, whether that power has been rightly exercised or not, that is the question.
The power is not there. Power to extend is for closing date, not for extension of the closing date after closure. Lord, my submission for lordship there, Lord, the power to extend the date is there, but not after closure. After closure, my lord, something is not there. How it can be extended?
Whether IEM has the authority to dictate extend the time period and to revise a clause after the bid closure date, that would be.
Because generally I don't do much the tender matters, but in my simple understanding, out of the other authority outside cannot dictate the bidding authority
Yes, that is what is coming to my mind.
Otherwise, my lord, what will happen? That bidding authority will do something and any other authority will dictate. And that dictation also has to be in terms of the promotional.
Where is the reference of IEM except that clause? Where is the reference of IEM in the bid document?
IM
There used to be other reference also in the bid document.
Integrity pact is there.
That's only in respect of the integrity pact,
Nowhere else.
nowhere else. Integrity pact is altogether different. So my submission before lordship will be there, that when they are 8 months from there, they have waited for it. They may file the affidavit in 3 weeks. Lordship may consider it, still then it may not be given effect. That will be my humble.
Okay. So my early going home is, I'll examine them. I'll find out.
My lord, at your lordship.
Yes, anything to say?
Only thing is that lordship, this is of paramount public interest, so lordship may not be pleased to stay the proceedings. Let us go ahead, subject to final outcome. If my friend
So
is
many amendments, Mr. Soikia.
the amendments are at the behest of the parties. It is
No,
not that
8 months, 8 months.
8 months. Who has done? Who has gone there?
Not gone for 12 amendments, are not at my instance.
No, it is not like lordship. One thing is very clear. First, let him establish his eligibility on the original closing date.
Not necessary, my lord. I submitted my technical bid.
Raising the voice will not improve the case. Raising the voice will not improve the case.
What my learned friend raises much more higher voice, my lord. The technical bid I have given you a seal cover that will be opened and I will be found whether responsive or not responsive. If I am not responsive and I mention in letter that I am responsive, whether it will be accepted, whether I will become eligible.
Once you do not have the eligibility, lordship, a person is not eligible, he cannot challenge any other things other than.
I am challenging the jurisdiction, I am not challenging anything.
So if the jurisdiction is challenged, he himself has approached IEM twice.
I am before the closing date, not after the
So
closing
they
date.
have submitted to the jurisdiction of IEM.
No,
IEM, that is not the case, that it is not his case. That clause, that in this clause where IEMC is referred, that clause is not under challenge, lordship.
why I should challenge the clause? I leave it on lordship, my lordship may fair
So
consideration.
my humble submission is a paramount public interest, lordship, that process of tender should go on. Lordship, if any third party is right, lordship may pass an order that it will go on and the final out any decision of us will be subject to.
When
final
can you
out-
file the response?
I'll file it in 2 weeks time, lordship.
Disclosure about this QIPE.
Yes, we'll do that.
QIPE, because two parties have come after.
We'll
the disclosure.
file it before vacation is over. We'll file it and lordship may take up the matter on 26th or 27th. But let
7 days time to me for filing reply, my lord, or 5 days time. But
yes, we'll file it by 18th or 19th. It will be filed. We'll file it by 18th. Lordship may give the date.
Within 5 days, my lord, I will.
They
file
will
it.
give the response by 25th. Let the matter come up on 27th or 28th.
No problem.
Mhm.
I also don't want to, my lord, that the public, what must be delayed, but when 8 months, there was no urgency. 3 weeks, nothing is going to happen. Rest, I am only fully in the hands of lordship.
Yes. Only question which is rising in the mind of the court, whether IAM can dictate to revise.
IAM is not dictating terms and
Because
it is
it
not
is-
mandatory to follow it also. It is not binding on us. If lordship, let me place this sequence of events then, lordship. There, in so many times, IEM hears both the parties and they gives a decision. We may accept it, we may not accept it. But when it is very fair, very rational, and it is acceptable to all parties, these are all incorporated. And when it is incorporated, nobody is challenging. Now 15th is because of that, what triggered this challenge? Because their application for changing or tinkering with the original closing date. That is why this 15th amendment has come to be put under challenge. Till 14th amendment, they were not aggrieved by any means.
But whether that eligibility as on the original date of closure,
Yes.
that had changed in throughout this
No, it has not changed. The original date,
amendments up to 12 or 13.
original eligibility criteria, it has not changed.
That original date.
The date has been changed because pre-bid meeting requested for something else.
No. Date is changed. Eligibility criteria on the original date.
It not changed.
Not changed.
No change.
So
That is why they are aggrieved. They are not qualified. They knew very well. They took a risk on which date? Actually, page 86, Lordship will come, kindly come. Execution of the job. Bidders must have the experience in execution of the following. So there are certain criteria. They do not fulfill the criteria of X, Y, or Z. That is why all these grievances are being raised by challenging the 15th Amendment, which has no bearing on this.
the first line, that bidder must have the following experience during last 7 years reckoned from the original
Closing date.
bid closing date.
Bid closing date.
That was on
7/10/2025.
7/10/2025.
So we are not giving
That was retained up to say 14th amendment.
till today. Till today. So we are not fair or unfair to anybody. There is no biasness. So everybody is getting a level playing field. Their application before the IEM and also before the oil authority clearly establishes the fact that they were not eligible on the original closing date. So if we open the technical bid, we will come to know who is technically qualified, who is not technically not qualified. And precisely that is the reason why they want that the technical bid should not be opened.
I want that the technical bill should be opened earlier. See, whatever the tenders are there, without application of the 15, open it.
Is it correct, Mr. Dr. Saraf,
My lord,
that you submitted an application before the oil
my lord.
on 14/2/2026 to amend a BC clause that technical experience of the bidders to be evaluated from the actual bid closing date rather than the original bid closing date?
Yes. There's no dispute about it.
So your application was replied when by the oil?
I have the reply with me.
That no amendment.
It
Reply kab aayega?
26/2. On 26/2, the oil's reply. In the meantime,
26.
they approach IAM also. Oh, sorry.
My lord, the issue subject to, I'm sorry, my lord.
All these facts we will bring it in our affidavit.
23/2.
Lordship.
Is it correct?
Not
23/2.
23.
Oil white email responded to the petitioner that the technical and financial criteria of the bidders are evaluated as on the original bid closing date by oil in all its tenders. Is it?
23rd we submitted, there is no dispute.
No. On 14/2 you have submitted.
My lord, there is no
Oil
dispute.
replied on 23rd
That, my lord.
23rd February.
No, that I have to find out. My learned friend has
No,
said that
this
is
is
correct.
what the respondent has said.
No, there is no, once my learned friend
This
is,
is a standard practice adopted by oil in all its tenders.
once my learned friend is placing it, there is no difficulty at all. I will not dispute that one. The only thing which I am placing before lordship that as per the clause 4,
So after the reply, you approach the IEM.
my lord,
On 24th.
my lord. That too before closing,
That too before closing.
my lord. My lord, my learned friend made a submission for lordship that he is trying to find out ways and means to get the benefit by challenging 15.
Whether your approach to the IEM and this last extension for change of original bid closing date, has it been averred?
Yes, that is not there. But that is not there.
So this is a very vital fact. They have not disclosed.
You made a request on 14.2 to amend the BEC clause.
Well, I some just my learned friend is saying that it is suppression of material facts. Well, the suppression of material facts as regards the issue which is there before the court. The issue before the court is that the amendment number 15, whether it can be extended, whether the conditions can be changed or not. This issue has no bearing on the amendment of 15. If I would have challenged the earlier one, this would have become irrelevant, although it was proper on my part. We missed it by any means. Lordship has come across a case, my lord, of the Supreme Court where the appeal filed by the authority was not disclosed in the writ petition. The apex court said that is not a suppression of the material facts.
Those are subsequent.
Well, I am submitting, my lord. It was proper, I admit, my lord. It would have been better and proper on the part of the petitioner to also mention this issue. When we have given such a document voluminous, why we should miss? There was no intention at all. But my submission for lawsuit with that, my lord, that this document has no bearing on the issue which had been raised in the writ petition. The issue which has been raised in the writ petition is about amendment number 15. And on that issue, this had no relevance. This would have been on relevance if I would have challenged the clause. Then if I don't disclose, suddenly it can be there. But according to me, my lord, in my humble submission, this has no relevance to the issues raised in the writ petition. And the suppression of material facts can only be said that suppression of material facts in respect of the issues which are raised in the writ petition and which are necessary for deciding the writ petition. The lawsuit is not deciding the issue that whether it should be 28 or whether it should subsequent, that your lawsuit is not deciding. My short issue is only these two issues before your lawsuit, that whether the power authority is there or not. And third issue, although I have not examined, but your lawsuit has in fact.
Firstly, this is not a statutory contract.
My,
Right. It falls in the category of
yes,
non-statutory contract. So there is no question of any Article 298, 299, all this.
no.
And this will be governed by the bid document. And there are two clauses which are conflicting in nature. One is 4 and one is 18. And 18 is about extension after bid closing date.
No.
Right.
No, my lord.
Let us have it again.
Well, once again, if you lost.
Normally, no request for extension of bid closing date.
Not
And
after
time
closing.
will be entered in. However, oil at its discretion may extend
the closing date.
the bid closing date and time due to any reasons.
So closing date, after closing date, it is not there.
So extension is there.
Extension of closing date, then it 12 times. After closing date over,
No request for
that power is not there.
However, it may extend the bid closing date or time due to any reason. May extend the bid closing.
With this honorable court was also held. It cannot be done.
Anytime prior to deadline of
That your lawsuit will examine all the issues when the writ petition will consider. Your lawsuit will consider the merits, my lord.
made for any reason where it is only
The question is. Well, one more judgment if your lawsuit may. I have also sold page 192. I'm taking a lawsuit time on the last day, my lord. I'm very sorry for that. 191, my lord. This one will put this one. Division bench now? Division bench now? Division bench. And lossy may see page 192.
Yes.
The last paragraph, my lord. Let us consider the meaning of the extension in the context of rule so-and-so rules. Would the governor extend the period of lease? Well, after the expiry of the period of lease, the extension used in the rule connotes the existence of something to be extended. When the term of lease has expired, the same term will be extended. When the closing date is over, where is the question of extension? Lord, what benefit I will get? That is a different issue altogether. Oh, petrol station.
Okay, on allows it, Alex. Size and otherwise, what is the time, Mr. Soikia, you need? 2 weeks.
By 18th, I will file the counter.
And Mr. Dr. Saraf?
5-6 days is sufficient.
6 days. 18.
25th, 26th, whenever.
24.
25th is Saturday, let it be 27th.
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 Let me go through it.
Well, only
I thought that is why I called all the listing yesterday. Well, all these listings so that I can buy midnight soil.
Normally, Milord, earlier, Milord, on the last day.
No, all permission granted for yesterday.
Then, Milord, after 1:15, the court was not there because everybody.
I'll be the last man to go out of the court premise perhaps.
Well, my only prayer, although.
Date is 27th.
Well, only unusual prayer, Milord, whatever your lordship may pass the order. The 10th is the last date. So, whatever, Milord, tomorrow is the election.
Let me think it over.
Well, whatever your lordship may think, it will not, but if you can get your order, Milord.
But date is 27th.
27th.
Whatever be the way, let me think it over.
Way, Milord, your lordship, I am totally in your lordship's hand, Milord.
Let me.
Only we allowed modification of the
Yes.
quantum of the bid value or the bid value amount. That was the only permission.
Well, the question is that if
there is no other change.
Power is there.
If somebody wants to change his bid regarding the financial bid, that is permission. No other changes are allowed.
If the power is there, they can do it. Anything can be done. If power is not there, nothing can be done. That is the only issue.
So my prayer is that Lordship may allow us to go ahead and subject to outcome, whatever decision.
And my prayer, I made the decision that.
Highly obliged.
Date is 27 as convenient to both of you.
My Lord. Highly obliged, Lord, for giving the special year. You've taken a lot of time on before the petition.
I have still matters.
We have done weight training with the petition.
So not got it bound, Milord, otherwise because the unlisted was there. Otherwise, I would have given the a binding one so that it would have been easier for me.
Okay, I have few other matters.
Lord, highly obliged.
This is open. I am keeping it open about the interim prayer.
The interim period will be considered by your lordship, will pass whatever orders are there.
By today, I'll pass the order.
Right.
By today, I'll pass the order.
That's similar.
That is what I said. I'll be the last person to go out of the court premises.
Normally also, my lord, your lordship was very late after the dictation and all correction.
Okay.
Daily list, item number 3 for admission.
This is your lordship. Lordship, an affidavit was required to be filed by the PWD.
Yes, loud.
An affidavit was required to be filed by the PWD.
PWD, yes.
Lordship.
Anybody from PWD? Call Mr. Nayak. Mr. Nayak. Yes, PWD needs to file an affidavit in this matter. He's not here.
Lordship, I am informed.
Mr.
J. Lotha, Lordship.
J.
Lotha, Lordship.
Lotha, Land Council petitioner, and Miss
On behalf of
Terang. Land Council on behalf of Mr. R. M. Das. R. R. K. Talukdar. Land Standing Council, Accountant General, for the respondent number 6. Finance,
Lordship, I am appearing on.
R. M. Borua, on behalf of Mr. H. Alia, Standing Council, Finance 5. Mr. D. Upomoino,
On behalf of Mr. B. Gogoi, Lord.
Land Council on behalf of Mr. B. Gogoi, Land Standing Council,
PWD.
PWD, as sought for and is granted. For the phone number 1, 2, 3, 4, as sought for and is granted. Time till 18:05 to file the counter affidavit.
Lordship, my humble apologies, I could not come here in time. Lordship, there is a communication which was given from our side to the court, the Honorable Court. I believe it is a part of the records as per the order dated 2/3/2026. 26, Lordship, 2/3/2026. Lordship, a communication was handed over to the court and the Honorable Court kept it on record. Lordship, may I have a copy of that communication? With that copy, we can file our affidavit in opposition.
Find out if it is available, then Courtmaster
Lordship,
supply a copy to
Lordship.
Mr. Bhuya.
Lordship,
I'll you guys.
much obliged, Lordship.
Item number 11.
Yeah, please, Lordship.
Yes.
Lordship, here it's a grievance is that non-release of security deposit as well as the final bill winner. Now the respondent have filed affidavit, they admitted they are both due, Miller. Lordship will find the
Yes, Mr. Bhuya.
Lordship.
flag A is the affidavit filed. Paragraph 4. Paragraph 4 is the admission.
Heard Mr. M. Mohanto, Learned Counsel for the petitioner. And Mr. M. Bhuya, Learned Counsel.
Lordship.
On behalf of Mr. B. Gogoi, Learned Standing Counsel, Public Works, Union Bracket Roads Department, Assam, for the respondent number 1, 3, 4, 5, 6. And Ms. R. M. Borua, Learned Counsel on behalf of Mr. H. Alia, Learned Standing Counsel, Finance Department, Assam, for the respondent number 2. Yes, Mr. Bhuya,
Lordship.
your affidavit.
The stand-in paragraph.
How much time you need to complete the entire formalities? Chief Engineer has said.
Lordship.
What more is required?
Lordship. Lordship.
It appears to have admitted.
Lordship. That is.
And it is 10 years old, due. 4 months?
Lordship, can it be 6 months considering it is over?
4 months you do, otherwise face contempt.
Lordship.
The petitioner is a registered PWD class 1A contractor. And it is stated that pursuant to an invitation for bid, IFB, issued by the respondent number 3 for a contract work para 3 development of Margarita Deomali Road in Tinshukia district in Assam under social and so likha ase pencil contract work for sort. Dated 26/2012, para 4 kas. Comma. The petitioner participated in the tender process by submitting its bid. First, upon evaluation of the bids of the participant bidders, comma, the petitioner was declared as the successful bidder, and on 20/09/2012, comma, a letter of acceptance was issued in favor of the petitioner with a direction to sign the contract agreement to proceed with the contract work. First of all. Accordingly, comma, a contract agreement being para 5 was executed between the petitioner and the respondent authorities in the PW Border Roads and NEC Works Department. And subsequent thereto, a notice to proceed with the contract work was issued to the petitioner on 11/10/2012, instructing the petitioner to proceed with the execution of the contract work. Full stop. Upon receipt of the letter to proceed, comma, the petitioner proceeded to execute the contract work and completed the same
on 10/2/2016. Page 27. Page 20.
page
27. Serial number 9.
on 10/2/2016. Full stop. After carrying out an inspection, comma, the respondent number 6 and respondent number 6 issued a completion certificate on 19/7/2016, certifying that the contract work was physically verified by him and found completed in all respect as per specification, drawing and tender agreement. And the physical progress was achieved to the extent of 100%. Post of. After, in the completion certificate, comma, the value of the contract work was mentioned. Post of. On after issuance of the completion certificate, comma, the petitioner prepared its final bill and submitted it after with the counter signature of the respondent authorities. Post of. It is a grievance of the petitioner that despite completion of the work, comma, only a part payment has been made. Against the execution contract work. Full stop. Despite lapse of more than 10 years from the date of completion of the contract work, comma, the remaining amount, the outstanding amount of rupees
23 lakh.
3,65,923 and the security amount deposited by the petitioner have not yet been released
Is the amount
till date,
16 lakh 68.
despite repeated approaches and representations made by the petitioner before the respondent authorities. Post of para. In the respondent authorities in the public works within bracket border roads and NEC works has filed an affidavit in opposition to the respondent number 3. That is the chief engineer, PW within bracket border roads and NEC works department. Some post of. Where in the affidavit in opposition, comma, the respondent number 3 has averred that the total liability of the contract work stood at rupees 3,1,69,523, and out of the said amount, comma, rupees 2,78,03,600 has already been released to the petitioner. Post op. As a result, comma, an amount of rupees 23,65,923 has remained to be paid, and the said amount could not be released to the petitioner due to non-receipt of FOC. Full stop. In the affidavit in opposition, comma, the respondent number 3 has stated as under page 38, D to B. In paragraph C of the 6 of the affidavit in opposition, the respondent number 3 has admitted that the contract work had been executed by the petitioner to the extent of 100% on 10/2/2016. First of para. From the affidavit in opposition, comma, it has clearly emerged that the respondent number 3 has clearly admitted your security amount is what? How much?
16 lakhs 68,215.
Has clearly admitted the extent of liability as rupees 23,65,923 as outstanding against the contract work, and an amount of rupees 16,68,215.
Yes.
Towards retention of the security deposit amount. Full stop. As it is stated that the amount, full stop, Mr. Bhuyan and Council, paying for the respondents, authorities in the public works within bracket, border roads and so and so, has submitted that the entire process for a period of 4 months would be needed to complete the entire process to release the said amounts to the in favor of the petitioner. First stop. Para. The petitioner has completed the contract work as far back as on 10/2/2016. First stop. It cannot be the respondent authority in so and so department cannot be oblivious of the fact that the petitioner had completed the contract work, making expenditure out of his own fund. Full stop. Therefore, it is obligation is cast upon the respondent authorities to release the said amount within a period, within as expeditiously as possible, or was cast upon the so-and-so to release the said amount as first of. But in the meantime, a period of more than 13 years have elapsed since 10/2/2026. So therefore, this petition is directed or is disposed of on therefore, the respondent authorities in the so and so, more particularly the respondent number 3, including the respondent number 3, are directed to release the amounts mentioned above, admitted to be due to the petitioner within a period of 4 months from today, after completing, within a period of 4 months, after completing the entire formalities within a period of 4 months from the date of receipt of a certified copy of this order by the petitioner, from the date of submission of a certified copy of this order by the petitioner and the office of the respondent number 3. First stop. It is further observed that in the event of failure to release the admitted dues to the petitioner within a period of 4 months, the same would entail interest at the rate of 6% in the date of payment. This order is disposed of the
Item 12.
Yes.
Yes, madam, we are waiting for the instruction, madam. We have not received the instruction, madam.
You should have received the instruction
Yes, madam.
because there is a clear
Yes, madam.
direction. Madam, your name please.
M. Sharma.
M. Sharma for the petitioner. Is present. Mr. M. Chetia, Junior Government Advocate for the respondent 1 and 3, has submitted that he needs 3 further weeks' time to obtain instructions on the matter. The Land Standing Council, Environment Forest Department for the respondent 2 and 4 is found absent today on call. The list like is on so and so to enable Mr. Chetia to obtain the necessary instruction in the matter.
1805. Item 13.
Your Lordship, my senior AK Purchase is not well today.
What did I do?
Yes, Mr. Blacklisting.
Lordship, in this matter, we have not yet filed our affidavit, Lordship, but one similar matter is there, Lordship. Our allegation is that there are 2 entities.
Raju.
Yes, using the same, pen.
File it to can decide.
Lordship, let me find that affidavit. And then both the matters may come together, Lord.
Mr.
I am S. Islam, appearing on behalf of.
As Islam Learned Counsel for the petitioner is present, Mr. P. Nayak, Learned Additional Advocate General, appearing for the respondent number 2 to 5. Has sought for and is granted 3 weeks time to obtain essay instructions and to file the counter affidavit on behalf of the said respondents. Lays the case on so and so. May, did you? May.
2005, 20th May.
File affidavit, we can
Lordship.
decide Raju or Raju, what?
Lordship.
For orders, item number 15.
Yes, Mr. Pathak.
Not, our case is that it's actually an inter-party dispute where PWD had intervened by my lord,
Okay.
passing an order.
Today I will not apply my mind.
My lord.
When do you want to file Mr. Bhuya and Mr. Chakraborty?
Lordship, we have received the instructions.
And Mr. Chakraborty? Okay, B. Pathak, Learning Council, heard Mr. B. Pathak, Learning Council, what a petitioner. Mr. M. Bhuya, Learning Council on behalf of Mr. P. Nair.
It would
Be
be
good.
good.
Learned Additional Advocate General for the respondent number 1, 2, and 5, and Mr. A. Chakraborty, Learned Counsel for the respondent number 6. First up, both Mr. Bhuya for the respondent number 1, 2, and 5, and Mr. Chakraborty for the respondent number 6 have prayed for, and I got granted further Tuesday to file their respective counter affidavit, list the case on so and so, the interim order passed earlier.
1805.
1805. Much obliged.